Hey everybody, it's Debbie. Welcome to my channel. Did the portal not work? It's only 3. Well, I think that's all we had over there. Everybody bailed. And I hope they didn't bail for the trial because the trial hasn't started yet. They literally just started and they're doing motions. So we didn't miss anything. We missed absolutely nothing. So if you're new to my channel, welcome. If you are in replay crew, welcome. If you are an OG, welcome. This is a day we've all been waiting for a year. I know that I'm excited. I know that my OGs are excited. We have been waiting and waiting and waiting. So let's go ahead and see what the motions are. I think I heard her say that there are some she's not going to decide on until the end of the day today. So they must not be something that's going to affect today. Oh, what are you doing, StreamYard? What are you doing, StreamYard? You are not doing anything. I told you to share my screen. They're not anything. What are you doing? You're doing nothing. Oh, well, thank you. Thank you for deciding to work. Why do I give you money? Why? No, you're not working again. Oh, wait. Are you going to work? You're going to work? You're going to work for the money that I give you? You're going to work? Really? No, you're not. Didn't think so. Okay, I'm going to reload. Oh, wait. You're teasing me, StreamYard. You're being a tease. I don't like tease. I don't like teases. Nope, gonna crash. Gonna crash. Nope, didn't crash. What are you doing? Oh, no. No. There will be many, many motions all through the trial. There may even be hearings because as experts want to do things and the other side doesn't want the experts in the trial.
This court is in session. Please be seated. 2282 CR 117, the Commonwealth versus Karen Reed.
So good morning. I see all counsel are present. Is to Mr. Clerk about needing to see me, but I received 4 motions over this weekend that I assume we need to at least talk about briefly. Commonwealth's motion regarding defense opening statement. I think the first 2 motions we can do, and the defense knows third-party culprit, that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader. Is it fair to say that the third and fourth motions, Commonwealth motion to enforce compliance with court's April 16th docket to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them. And I think we'll do that at the end of the trial. I mean, at the end of today. We'll hear both these motions. Mr. Jackson, I did see that a list of 100 or so is in your response to my order on Friday. Did you provide the text messages themselves? Have time, the juror's been waiting for some as many in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be
Don't start. Not today, StreamYard. Look, guys, our fan is back. Yay. Our fan is back. Yeah, we didn't miss anything. See, that's why I started at 9:30. Well, I started before 9:30, but that's why I scheduled it for 9:30. Denver. It's nice white mat there and little paint. There's a switch on the wall. And the air conditioner is very loud. It's hot. So it's in the court. I have to speak up because the fan, although beautiful with the gliding blades, does not allow enough aeration. The ice room is all heating the courtroom. How are you doing, guys? What can we say about the fan? We missed the fan. Over the year, we didn't see. Okay, that's all I got to say about damn fan. No, StreamYard, knock it off. From your fingers to God's ears, Jill. Oh, I probably shouldn't try to put any comments on the screen. Yeah, you can't hear me because StreamYard keeps muting me. It's just this fan. They're still at sidebar. StreamYard, I can see it down here in the little box. It says you're sharing the screen. There it is. Was that too much to ask? Jeez. Apparently it was. Because now my screen is purple again. So he went in car and leaving him dying. However, the timeline does not match up. There's a lot of suspicious circumstances surrounding the event. And I'd love to know why StreamYard thinks I have no internet. Because I have internet. I'm even connected with an Ethernet cable. Ceiling Dion. Yep. No, I have a picture now. It was just briefly purple. I'm dropping frames so I can see it because the fan keeps stopping. This spins down. I didn't tell you to do that. I don't know why it keeps saying I have an unstable connection because I don't. I do not. But it has said this for months. Even like I upgraded the new internet and it still tells me connected with an Ethernet cable. I mean, I did think there's probably going to be people that normally don't watch trials that are going to watch this. You know, like with the Johnny Depp thing, because like that's how I found LawTube. I didn't even know it existed. Like I didn't even know. I used to make fun of Travis for watching YouTube all the time. I was like, how can you just sit there and watch YouTube? Like I looked up stuff, you know, like video game stuff or makeup tutorials or, you know, beauty stuff or craft stuff. I looked up, you know, like crochet tutorials and stuff all the time. But to just sit there and watch it, I was like, how do you watch YouTube? I had no idea, man. No idea. And
You are muted. You are unmuted.
Okay, we're unmuted. Quit showing the fan. Let's go. Let's go.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoli, the Justice of the Superior Court, now holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated. 2282 CR1. Identify themselves for the record.
Morning, Your Honor. Adam Lally for the Commonwealth.
Morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Alan Jackson on behalf of
Good morning, Ms. Liv.
Good morning, Your Honor. On behalf of Ms. Reed.
Good morning, Mr. Lessie.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Good morning, jurors. So I have 3 questions I have to ask you because I haven't been willing and able to get started early. We sometimes have to deal with a few things before bringing you in. But we do appreciate your patience. So those questions are, were you all since we last saw you? Everyone said yes or nodded affirmatively. Were you also able to refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively.
Yeah, short bus.
Did anyone happen to see, hear, or read anything about this case since we last met? Everyone said no or shook their heads.
No, they all watched the
Thank you very
HBO documentary.
Jurors, can I have each of you stand and raise your right hands, please?
Jill, I just said that.
Do each of you solemnly swear you shall well and truly try the issue between the Commonwealth and the defendant according to your evidence and according to the law, so help you God?
Yes.
Thank you. You can have a seat. Jurors, hearken to these indictments. Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the 2nd degree and not in the 1st degree in violation of Massachusetts General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did operate a motor vehicle upon a way as defined in General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so the lives and safety of the public might be endangered. And by such wanton and reckless conduct so described, you caused the death of another person, to wit, John O'Keefe, in violation of General Law, Chapter 265, Section 13 and a half. 003, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24, Subsection 2, Subsection A and a half, Subsection 2. To these indictments, the defendant has pled that she is not guilty and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you say so and no more. Jurors, hearken to the evidence.
All right. Thank you.
It always say assault
All
and
right, members of the jury, I'm about to make some principles, procedure terminology that may inquire during the course of this trial. These comments are not intended to be a substitute for the more detailed instructions on the law that I'll give you at the conclusion of the case. So you'll remember that this is a trial of a criminal case. Ms. Reed is charged with
Robbie, we have a triplet. You're not going to believe it.
Second-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death, the indictments that Mr. McDermott just read to you. I'll describe the law in detail at the end of the case and the elements of these charges, but briefly, murder is the unlawful killing of a human being. In order to prove Ms. Reed guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. And leaving the scene of an accident after causing personal injury or death requires the Commonwealth to prove that Ms. Reed knowingly collided with John O'Keefe, that she caused him injury or death, and then she fled the scene. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, please remember that Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. It is merely a formal manner of accusing a person of a crime and bringing that person to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law never requires a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else. So let me share a few strategies that we have found useful. First, hate biases. Second, Keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, please consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, when I finish these initial instructions, the Commonwealth, Mr. Brennan, will make his opening statement. Then Ms. Reed's lawyer, Mr. Jackson, can choose to make an opening statement or not, because again, remember, the defendant has no burden of proof and doesn't have to prove anything. Her lawyer does not need to make an opening statement. An opening statement is a summary of what the lawyer expects the evidence at trial will be. It is intended simply to introduce the main issues in this case to you. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may present evidence on her behalf if she wishes to do so, but she is not obliged to do so. Remember, the burden of proof is always on the Commonwealth to prove that the defendant is guilty. The law does not require any defendant to prove her innocence or to produce any evidence at all. After all the evidence, each side will have an opportunity to offer you closing arguments about what conclusions you might draw from the evidence. Like the opening statements, the closing arguments are not evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you are to apply in your deliberations when you retire to consider your verdict. Your verdict must be unanimous. Let me speak briefly about our respective roles in this case. As the judge, my responsibility is to see that this case is orderly, fairly, and efficiently. The law that applies to this case. It is your duty to accept the law as I stated to you, whether you agree with it or not. Your function, you folks are the most important people in the courtroom. Your function is to determine the facts. You are the sole and exclusive judges of the facts. You alone determine what evidence to believe, how important any evidence is that you do believe, and what conclusions all the believable evidence leads you to. You will have to consider and weigh the testimony of all the witnesses of any witness and the extent to which you believe any witness. You can believe all of what a witness says, some of it, or none of it. It's entirely up to you. It is part of your responsibility to resolve any conflicts in testimony that may arise during the course of the trial and to determine where the truth lies. Ultimately, you must determine whether or not the Commonwealth has proved the charges beyond a reasonable doubt. The lawyers have their own important role in this trial. They are, of course, advocates, support their position. They may also object to evidence offered by the other side that may not be admissible under our rules of evidence. Similarly, we may engage in sidebar conferences out of your hearing. These sidebar conferences are not intended to keep secrets from you, but to allow the lawyers a little more time to argue their points so that I may rule on what you may consider as evidence. If I agree with an objection to a question, the term I will use is sustained. You are to disregard that question, and you're not to speculate as to what the answer might have been. In the same way, you're to disregard any evidence that I tell you is stricken from the record. If I reject or overrule an objection, I'll permit the witness to answer. This happens a lot. You'll find this during the course of the trial. If I let the witness answer the question, but you're not allowed to give the answer any more weight than you would have no objection had been made. Please do not hold it against the lawyers if they make an objection. That's the important part of the lawyer's job. The lawyers have to let me know when there is a potential issue about the admissibility of certain evidence under our law. You must decide this case solely on the evidence presented in this courtroom. This will include the sworn testimony of witnesses and may also include any exhibits that are admitted into evidence, any facts that I tell you have been agreed to by both sides, and any facts that I indicate to you may be taken as a matter of common knowledge. Questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers which you receive from the witnesses who are testifying under oath are evidence. So if a witness is asked, isn't it true that after you learned that your uncle left you money in his will, you poisoned him? And the witness's answer is no. Based solely on that question and answer, there is no evidence that the witness has an uncle, that the uncle had a will, that the uncle left the witness money, that the witness knew that he did, or that the witness poisoned him. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I may make, the lawyer's openings and closing arguments, and any comments they may make are not evidence. I will emphasize this point because it's crucial to your understanding of your role. If the lawyers or I make any comments during the trial, those comments are not evidence, and your verdict must be based only on the evidence. In Massachusetts, lawyers are not allowed to make comments other than during opening statements and closing arguments. They are permitted only to ask questions, but they cannot comment on the witness's answer. If a lawyer comments, you are to disregard it. In this way, communication in the courtroom is not like everyday conversation. If a lawyer seems to agree or disagree with an answer, or if a lawyer expresses confusion or any other reaction or emotion, you are to give no weight to what that lawyer does. In the interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. In a similar way, any comment I make is not evidence. But of course, you can't disregard what I say when I provide you with instruction or direction. Remember, however, I'm the only one who can instruct you or direct you in any way. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. Now, in this case, I anticipate that we will go by bus to an area that you'll hear about during the trial. You may consider as evidence anything that you observe about the layout of the area, including the scene of the alleged crime when we do go there. I will give you further instructions prior to our leaving for the view. Now, in this case, I'm going to allow you to take notes. Any jurors who wish to take notes during the course of the trial, except during opening statements and closing arguments, because remember, those aren't evidence. If you wish to take notes, you may do so once the evidence begins. Notebooks and pencils will be provided to you, and they're destroyed at the end of the trial. Nobody sees them. You're not required to take notes. The choice is entirely if the case involves many witnesses or complicated issues. Notes also can help you remember specific testimony or evidence, such as times, places, dates, names, relationships, distances, things like that. Other jurors may feel that note-taking is a distraction, may to be hearing and evaluating. If you do, I suggest you keep them brief. They are not considered official transcripts of testimony. However, bear in mind that although the court reporter is recording everything that transpires here, we do not notes. Please remember that how a witness testifies may be just as important as what he or she says. Therefore, your observations of the witness's appearance and demeanor on the witness makes. If you have any trouble hearing or seeing during the trial, please raise your hand or let a court officer know, and we'll make any necessary adjustments. We generally take a morning recess at around 11 o'clock or so, but if you need a break at any other time, please raise your hand and let a court officer know. We'll take a break. If you need to communicate with me during the trial, and I'm not suggesting for a minute that you need to, but if you do, please speak with the court officer or give the court officer a note to bring to me. Now, I'm going to address the issue of public interest in this case again, and the duty of this court and this jury to adhere to the rule of law, because it is so very important. John Adams famously said that we are a government of laws, not of men, and that the law must be deaf as an adder to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with great intensity, but unbound by any oath or even any inclination to follow the actual evidence. The law works in a different way, and the difference is crucial to our system of justice. This jury, selected for this trial, will hear and judge the evidence. You will decide what the facts are. Where the evidence is contested, you will determine where the truth lies. Ultimately, this jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this trial will be decided by you, an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, you must ignore it so that the rule of law will be upheld. Which leads me to the fact that it is very important that during this trial, until you deliberate, you must not discuss this case with anyone. This includes your family and friends and even your fellow jurors. Nor should you allow anyone to communicate with you about any specific aspect or any aspect of this case. You must not conduct any independent research about this case, the matters in this case, and the individuals involved in this case. And must not consult the internet or to try and find out information from a source outside the confines in this courtroom. Please be very careful with your social media use. Please do not use X or Twitter, Facebook, Instagram, or Reddit. Though you may never have seen anything about this case before on your social media feed, you cannot control what may pop up. You should also remember that use of these platforms can be public and traceable, and any searches undertaken or information received by you can and likely will be discovered. So please be extremely cautious. If you inadvertently see something about this case, please disregard it and let us know. As best as you recommend, or anyone associated with either side, including the lawyers. Please do not visit any locations that may be mentioned during the trial. We'll go on a view, as I told you, and I'll discuss that with you before we go. Remember, you were instructed that you must not, and you assured us that you would not read, watch, or listen to any account of any aspect of this case in any news media, social media, or from any other source. It is critical that you follow that instruction. Finally, please continue to keep an open mind. I know that you will try this case according to the oath, that you will and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict. And that's all we ask of you. Time for the opening statements. Mr. Brennan.
Thank you, Your Honor.
pop up?
At 6:04 a.m. on January 29, 2020, Armel Fire paramedic Timothy Nuttall knew what that meant. His heart skipped a beat. He raced to his equipment and he picked up the bag, which was meticulous. There was a sign and a signal, and then there was a voice giving calls for a firefighter paramedic. That means the person's heart has stopped. He didn't know who it was. He didn't know where it was. He took his bag, just got into the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off the 34th Fairview Road. As they drove, firefighter could not see anything, hear anything, other than the end of the ambulance. He calmed himself, he steadied himself. This is what the fire, and he focused on his task. He looked around the back of the ambulance to make sure all tools were in place, and it was well stocked.
Thank you, Carla. I appreciate it. Thank you so much.
He calmed himself and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and eerie calm was above him. As the car pulled up to 34 Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow, and when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man and he reached down, and he walked over to that defendant, Karen Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Flamati, the chief, and he said, "Come back, let's go." They're presumed to have passed. Sometime you can still save a life. So you'll see on a dash cam video, you'll hear from testimony, he went back to that man who was John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain as he kneeled over John O'Keefe, he looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed and he said, "What happened?" And you'll hear her words to firefighter Nuttall. She said, "I hit him, I hit him, I hit him." And it was at that time, with the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context. They didn't reconcile with the injuries. They didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator. He is not a detective. He's a first responder. And so he takes that information. It was useless to him. He continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body lay his cell phone. They bring him to the ambulance, and while they're bringing him to the ambulance, you'll see on the videos that other first responders speak to the defendant. one first responder before 90, she will say, I hit him, oh my God, I hit him. And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background. And during that conversation, you won't hear see the defendant with a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, the third first responder, I did. They bring Mr. O'Keefe to the Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his course. And unfortunately, firefighter Nuttall's first instinct was accurate. John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in a dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited 2 minutes. And the facts and the science and data will tell you that despite the fact the argument
He didn't stand by the road. He went in the house.
put the Lexus up to 75% acceleration. There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded. Yet he was. And she simply drove away.
Nobody saw him
Before
when
I tell
she
you about the data,
supposedly hit him.
and the science, and I walk you through that. I'd like, he was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in
Doing a better opening than Lolly did. I'll give him that.
Car, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man.
Why is that line number 3?
Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. John O'Keefe was a help. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his home. They were his passions, his love. He was a new parent. Successes, failures, like all parents, and he raised the children with the help of people in the community, with the help of his brother, with the help of his family, and they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though The defendant had her own home. She was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together. They did activities with the children together. She helped with driving the children, feeding the children. It was a steady relationship until about the beginning of 2022. And then things began to unravel. There was tension. There was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave, but she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022, and you will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only companion to John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on, and Waze is like a breadcrumb that will show exactly where the phone goes second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping, moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Okay. And the third thing, remarkably, will be an expert in this case who found a data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to the timeline of that night.
Very much.
After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar. A blizzard is pending, and people are getting together in a celebratory mood. They go to McCarthy's and you see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrive at 8:50. They stay till 9:45. She consumed at least 7 of those drinks in less than 2. The last drink, you'll see when they leave the bar.
Hey, Judy, yours calls me at least once a day.
Go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friend and the defendant and many of the people there. And they spend some time together, they're drinking, and they all do a shot. And that will be at least the 8th drink within 3 hours. So you will see from the data, not just the cell phone data, but there's some other very important data. And the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, or there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so
That's gonna be
they leave
impossible to
the
count.
waterfall bar at 12:12, and you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're gonna go back to 34 Fairview Road, what we talked about earlier. They're gonna go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, you will be able to follow them with this location data. When they go back to Fairview, they don't know exactly where it is, and they get lost. And so John O'Keefe makes a phone call, has a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, and trying to get directions, Jen McCabe tells John O'Keefe, it's near Bella's mom's house. You'll learn that Bella, or her mom, is somebody that John had dated before. And so as they make their way through Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop, and then they do a
called a
three-point turn in the
cul-de-sac.
driveway. You see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because that's 7 minutes before the collision. And you'll see from the waves exactly where the car was. You'll see from the black box the event of the three-point turn in the driveway, and then a return down to Fairview. But before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights. One of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, will appear because of the waves and be counted second to second, never stops. It rolls very slowly all the way to the end of the yard in the corner where there's a tree line and a flagpole. And they reach that location at 12:34:33. And they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out, the person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside, 12:27, John gets a text from Jen McCabe, park behind us in the driveway. 12:29, she texts again, are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. He will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus, and in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message to Jen McCabe. There's now 12:32:09. Close to the last time. It will be the last time he uses that phone. From the waterfall bar, you see that he keeps it in his back pocket. And at that time, 12:32:09, last user, he has 7 more seconds to move before he lies dormant the rest of the night. We'll also have the information from the 30-second variance, but it's right in the heart of that time. And you will see the data at that time when he makes his last movements with the phone is when her car leaves 34 feet of neutral and then shoots into reverse with the tires spinning right towards him. Right looking it up. You'll know they're arguing because the next tells the firefighter I'm sad because our last moments were fight. She drives away. They said, made later statements that when she left, he didn't look mortally wounded. He lied on the
Well,
ground.
it's better than Lolly's opening.
Light dusting of snow, the snow now picking up. And he's just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the warm car. Now that he's been outside the car for 5 minutes, it drops to 72 degrees. She drives to his house. She makes a phone call at 12:33 after she's left Fairview. She calls again at 12:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking hate you. Pardon my language. You will hear the simmering. And she leaves that message. He lies on the side of the road. He gets another text message that's unanswered. Where are you? 12:45. Battery temperature 61 degrees. So he gets almost 40 calls from the defendant that night. His phone rings, but it never rings. You'll hear from an expert that the light never initiates, the healthcare data never moves. John alone with his own link again in his phone. At 12:53, cell phone drops to almost 60 degrees.
I'm not counting anything.
12:59, the defendant leaves
Girl
a
is
message
counting something.
on
I don't
John's
know.
phone.
Ask her.
She hasn't spoken to anybody. Nobody has spoken to her, but her message is out. You'll learn the message says, John, nobody knows where you are. And this is where the plot in the cover-up begins. The evidence will make clear that she knew he was there, but she did not call 911. She did not go back to him. She did not leave an anonymous tip. She left. The night wears on. It's now 1:07. Battery temperature 55 degrees. 1:14, she calls her mother. No answer. 1:14:53. Battery temperature 50 degrees. The defendant had healthcare data on her phone as well, and you'll hear that it stops around that time. You later learn that she admits to falling asleep or passing out. But then she wakes. 5 o'clock. She is frantic. She wakes up from these and she is unintelligible. She calls Jen McCabe, and you'll hear Jen McCabe recount out of her deep sleep. She wakes up and she hears, Jen, Jen, Jen. Screaming Jen's name.
StreamYard, knock it off. No. Stop.
Calls down. And then she, what's going on? And she told, well, I left him at the wrong sidewalk front. You didn't leave. She hangs up. And Larry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids and they interacted with the family. She calls her and says, I think John got hit by a plow.
Yes, he did.
Now, Carrie, with that information, calls 911. She calls hospitals. You can hear her voice. She's concerned. Okay. And then she gets another call from the defendant. And she tells the defendant, waiting for her to arrive. She learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house, Terry Roberts. The other, when she does, she's on Bluetooth, and she can hear the defendant say, my taillight's broken, my taillight's broken. And she looks, and the snowpack in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34th Fairview Road, but Terry Roberts takes over and says, we're going to go back to John's house. Maybe he's in the house and you didn't see him. So both cars, driven by Terry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Terry, enlisted into this task. Look for John O'Keefe. They cannot find him. And then when Kerry
AJ reminds me of a Bronco waiting to get let out of the chute.
Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they got to go back to Fairview Road, leave Mr. Lexus and John O'Keefe's driveway, and they drive back towards 34 Fairview Road. You'll hear it is blizzard-like conditions. It is dark; they can barely see a thing. Close to the edge of 34 Fairview, you hear the defendant start to scream, "There he is!" Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door. "Let me out!" Kerry Roberts stops the car and lets her out, and she sees the defendant run exactly to where John O'Keefe is in the darkness. Just where she left him. Kerry gets out of the car, starts to walk towards where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes this is one of her best friends in the world, is John O'Keefe. And she starts to try to do first aid. They start to move him, and coincidentally at 6:06, when they start to move him, the cold air hits that cell phone battery. It drops from 50 to 43 degrees. And they try, Jim McCabe calls 911.
I don't get the cell phone battery.
Police officer arrives, firefighter Nuttall and his crew. And when they lift him, that cell phone battery that is shot down to 37 degrees, Kerry Roberts picks it up and puts it in her pocket, and it immediately starts to warm. As she moves to help get a data, showing movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers. They're not sure, so they look in the area where John's body is and find a glass from the bar near his body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work of the Canton Police Department try to uncover a little bit around his body to see what they could find, which was very little. And then Kerry Roberts goes and picks up Peggy O'Keefe, tells her the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Kerry Roberts is walking. Peggy O'Keefe is going to go see her son, with her husband. And as she walks down the hall, Karen Reed is also in the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her in for evaluation to make sure she was safe. You'll hear Peggy O'Keefe tell her she walked down the hall to go see her son. The defendant was screaming, "Is he dead? Is he dead?" As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you'll hear that Karen was excited and yelling, "Is he dead?" She stops her excitement, becomes stoic. Doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to tell the children. Now, while she's out, the Canton Police Department sent an officer to the house to make sure the children are safe because they're alone if they're home. And when the officer pulls in, he doesn't notice anything, but you'll see on the dash cam video, his dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, a friend can take it down. And they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in. No condolences. Peggy. And they ask, "Can we go upstairs to John's room?" Or they come down. And quickly they leave. Now they got there from the defendant's father, drove his wife and the father to that house. But But when they leave, they take 2 cars. They take the Lexus with the broken taillight with them back to the defendant's father's house. And you will learn that when police start getting some of the information, they learn about the broken taillight, they learn information that she had told people that she had hit him. They went down to see her. And on their way down, they decided they would get a warrant to take the Lexus. When they get down to Dayton, where the car is, you'll hear from Trooper Buchanan. He took a look. They went in and spoke briefly to the defendant. They took the car, they brought it back to Canton. And so what you'll learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken taillight was littered around John O'Keefe's body. Littered around that area. When they got to the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug the excavations, they found the shoe on a little berm on the border between the street and the grass. You learn days later when they did a plant excavation, they found his hat frozen to the ground. Ultimately, they would find over the course of 10 days that the snow melted almost every piece of that broken taillight in that area. His hat, the sneaker, the glass. When the defendant left Mr. O'Keefe behind, he took with her something of Mr. O'Keefe called trace evidence. You'll learn the back of her Lexus around the taillight area, John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's hair.
I zoned out
Now,
and started reading tweets from it.
his head after he was clipped by the car. And you're going to hear from a very renowned doctor and neurosurgeon who's treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, from the cracked skull, it's called a basal fracture, it created an injury called counter coup. After he was hit by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusty one. The back of his brain, the back bouncing down the seat, showing that impact. And this neurosurgeon will tell you, treated thousands of patients, that this injury, to a reasonable degree, medical certainty.
Well, here's cuts. He changed the distance from 62 to 35, and Turtle Boy did it. You can't, in 62 feet, you can't accelerate to that speed. How are you going to do it in 35?
When the medical examiner for the state looked at it, they generally said blunt force trauma. They had it undetermined. So we brought it to the renowned neurosurgeon who does exactly this. You're also going to hear from an active reconstruction. His name is Doug Welcher. He does not work for the state police or local police. He was hired to take a look at this case and the data. He'll come explain to you exactly what I talked about, how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant struck John O'Keefe with her car. Now, just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people get murdered, shooting somebody, stabbing somebody, deliberate premeditation. Criminal structure on the law, I'm not going to trample that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted to dead. That's not second-degree murder. What we'll prove to you is she engaged in an intentional act at that speed in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act would possible second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is being seen after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him. He died. That's the whole group. This case will come down to the science and the data. The science and the data that cell phone is best for the science. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead to the truth in this. But after Miss Reed was charged, she
No
began
better than
what
Lowry's.
you'll learn as a campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it. And her statements to you will confirm what you already know from the science and data, what you will already conclude from the facts independent about what did that night. Admissions to extraordinary intoxications, her admissions to driving VLS, her admissions to being angry at John that night, and I guess it's her admissions that she told. Like to play for you clip one. We're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I tagged him in the knee and incapacitated him. He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in his in drunkenness and in the cold didn't come to again.
And this would have been.
Oh, she did say that.
Ladies and gentlemen,
The stupid thing to say.
simply follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29th, 2022, a very intoxicated defendant was angry and arguing
ready to go.
about his
Look at him.
relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back.
It is out of context.
First, he broke his head, and then this man who helped a lifetime of help was left at the corner of that yard, left to die with no help.
She said that. She said that when she saw him lying in the snow the next morning, when he only had the head injuries and the one scratched up arm. Same thing I say every time I see the pictures of him. He does not look like he's been hit by a car.
Words will confirm everything you've already concluded.
All right, thank you, Mr. Jackson.
Could I have just a moment to readjust?
Sure, the court officers will be kind enough to help you.
He made it sound like when he said it in his oh, he's not mortally wounded. I can drive away. That's the way he made it seem. That's not.
The evidence in this
Go.
case will establish above everything else 3 points. There was no collision. No collision. There was no collision.
3 points.
John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. you'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe.
Up, StreamYard.
Trial for something, for an event that literally never happened. Well, the evidence is going to explain it. And it can be summed up in the following text message.
Why?
Fired Massachusetts State Police officer named Michael.
Opening. Yes.
He was the lead investigator on this case. And he was talking about a fellow officer, a fellow cop who owned the property where John O'Keefe's body was found. Text message with a buddy. Question defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasoning their way out of it. They won't be able to excuse their way out of it. And they
Oh no, 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 no. Sorry, guys. I'm so sorry.
tell you is beyond
Yard.
any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Emergency
Yeah.
vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day. Even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn, he never secured the crime scene, never separated and secured witnesses. He never properly collected evidence inside or outside the home. Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation. It's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case, the case officer, Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State
Go an objection
Police.
in the back.
Investigated, suspended.
Mumbling. Stop it, StreamYard.
Found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case. Bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? The evidence showed every bit. Now, the Boston police officer, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert
Oh my God. Biggest trial of the year. Biggest trial of the year, StreamYard.
one reason, and one reason only. He's a Boston cop. Next conversation with his high school buddies. A text he never thought would see the light of day. Certainly
StreamYard, stop.
part out loud. He's a cop too. We'll give him a pass. Rank has its privileges. The evidence will show that's privileges by a Boston police officer, Brian Albert, and his friends, they do get. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Albert's house that night. I want to take a step back, if I could, and spend the minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the Waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Brians, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were just business as usual, out on a date on a Friday night. But that exact same video footage will lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier, she had put a stop to it. She had ghosted him.
Well, she
Common
started it.
parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the Waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen, they weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally The data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out. And when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never will learn what Karen had absolutely no way of knowing at the time. It wasn't that he couldn't, it wasn't that he wouldn't respond to her. It's that he couldn't respond to her. To a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John, his body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where, ultimately at 6 a.m., Karen found him the next morning. You will learn that John did not have a single
That's new.
injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury, not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Posada will tell you with many he would not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. La Posada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. Very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone. Dr. La Posada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. La Posada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brent in his opening statement, the Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door have been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house. And still one saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth. And he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did. And we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge. But again, we did. And the evidence will establish that the Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. Science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here. A collision. And there's no evidence of one. Zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie and the physics cannot lie. And I'll tell you with certainty, there was no collision with John O'Keefe. That to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. The Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that too is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. Shortly after Higgins completed that late night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation. A butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call? You'll also learn after this incident and within days, both trained investigators got rid of their phones. Both of them. And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing, just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start. And he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., little 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped according to their own data at 2:27 a.m., 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold.
Can you imagine hearing
She
that
misspelled
for
the first word.
time?
Hoss is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some very busy beat. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian morning. That area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m. And that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time, Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. Actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none. But they'll make the claim. we'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him. And she was worried about possibly the worst. He'd gotten out of the car when she found him at 6 a.m. on the lawn, where she last saw him going toward the house. Her mind started reeling. Oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him.
Yes,
That's what she was talking about.
Yes.
Your job will be to make sure that the evidence isn't presented to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other, a woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that the evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Saraf, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, I hit him. Not one. Not one civilian reported having heard Karen Reed say, I hit him. The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert, Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years long, close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family. And that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. Detective police officer. Coincidence. See how far it went. Michael Proctor was alone.
Was in his sister's wedding.
With all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, cover evidence. He secured it. He submitted it. He did it all. That's Michael Proctor. And he did it
StreamYard.
lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that tail light before any taillight fragments were found at 34 Fairview. Access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were two searches. The first and second search found zero, nothing around John's body, nothing in the street, and had the taillight in his custody and control. Suddenly, items started magically showing up, and not just a few items, 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. Came up with zero. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. DNA was on the taillight, but you'll learn that there was no DNA on the actual shards that they came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show, was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless Commonwealth is going to shift their theory that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors, because that's what this case is ultimately about. It's about the Commonwealth's burden of proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the House and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting Joe collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all 3 of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
Thank you, Mr. Jackson. Folks, why don't we take our morning recess?
How long? How long? How long, Beth? It's a short break. Brian, you're still here. I don't know what else to do. I clear out all my cookies. I shut it off every night and reboot it. I don't know what else to do. 15 minutes. Okay. Was it about the wedding? I think it was about the wedding. Was he the ring bearer at his wedding or his sister's wedding? He was the ring bearer at Proctor's sister's wedding, right? Colin? I think. So, yeah. I don't know why, like, they were like, okay, so Canton get recused. So we have to get the state troopers. Like, and then because it's a homicide, they have to get the state troopers. But they let Proctor do it. Recuse Proctor. He's friends with all of these people. Jeez. But I'm so glad that all of his disciplinary stuff is done and he was fired so he could get that in opening. I was like, yeah. Like, yes, that's perfect. I almost want to say we won already because he did all of that without accusing anybody. Oh, okay. I thought you were talking about the wedding thing. See, I forgot about that. That's why you didn't know about that, because I forgot about it. Yeah. That was like time when they were like, Canton can't touch the case. They let Canton, like, oh no, Canton can't investigate this case. And then during the first trial, when that EMT testified, they kept trying to get her to say that she was friends with Caitlin, and she kept saying, well, we went to high school together. I knew her from high school, but we weren't friends. And then I think that was like a weekend, and then people kept sending them pictures of them together on Facebook, and they wanted to get the pictures into evidence and stuff. And I don't know if they ever got them into evidence, but they were allowed. I think they had to wait until Caitlin testified. I don't think they recalled her. I don't remember now. But they showed them, I know they showed them to Caitlin, the pictures of them together. And they both said, oh no, we're not friends. But they were like, I think they were on the track team together in high school. And Alita is on her channel. If they're on the track team together, because I was on the track team, we did everything together. They were friends. And they'd been on trips together. They'd been to baby showers together. They were friends. They knew each other. Like, even people, when you do stuff together in high school, and I'm talking like, these girls are still young to the, like, they've only been out of high school a few years. So it's not like, you've been out of school 10 or 20 years. And so you're still at the point where you know these people. Like, there are some people that I went to high school with I've not seen since I graduated. But like right out of high school. So, but I think one of the pictures of them was just a few months prior, like I don't remember exactly how, but it was less than a year of a picture of them together at a baby shower. So yeah, they lied on the stand. They both lied on the stand. Oh no, we're not friends. Oh, I know you guys an Ethernet cable. I didn't even know what an Ethernet cable was. And we were so excited about the upgrade of the internet. Control plus. I hate this keyboard because I can't see it with the lights on. Because instead of didn't do anything. It did absolutely nothing. Nope. Oh, Spotify. Why is Spotify running? Go away, Spotify. That's not even what I'm processor. I got it. It just was it's slow. It took it a while to pop up. So it says the only thing that's running is Google Chrome and Task Manager, but there are 64 background processes. Processes? Process? But why is it Google Chrome? Help, Brian. It says memory 73%. Maybe, if it will cooperate. No, it's not going to let me do anything now. yeah, I was having really, really hard time with StreamYard. And then I wasn't shutting down the computer every day. And then when I started doing that, it got better. And I was like, oh, that's all I had to do to fix it. But then it started getting bad again. So I, okay. Oh, wait. Oh, where is it? I'm trying to share. It won't let me share it. CPU says 100%. But why? How can I get a new computer? Joy. Well, I guess I can start saving up my save a computer. Saying it's my internet. It's not my internet. I've got good internet now. Super good internet now. This is it. I've got StreamYard and YouTube. That's it. but it might end up working better. Now you use a browser. This is a long, short break. What just happened to my laptop? Well, crap. I'm just having technical difficulties all over the place. My laptop just died. I just plugged it in. I turned it on. It booted up really fast, and I was like, oh, cool. And then I tried to start Chrome, and it just died. Where's my goat? Oh, wait a minute. Are you kidding me? How?
All right, Mr. Brennan, your first witness, please.
Thank you, Your Honor. The both calls, Timothy Maddow.
Well, screw it. We're just going to do this thing. Who did he call?
Raise your right hand. You solemnly swear the Answer to the court and jury in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God.
Sir, could you pull the microphone down a little bit closer to you, please?
Yes, sir. Yes, ma'am. Excuse me.
All right, when you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce to the jury?
My name is Timothy Nuttall. I'm 28 years old. I've been a firefighter paramedic for ever since I graduated high school. I graduated in 2015. I took my EMT class and got my certification while I was actually still in high school. From there, I moved on to the BLS transfer side of EMS. There's 911 EMS, and then there's transfer, which is basically back and forth from hospital to hospital. I was brand new and very young, so I started on the transfer side, kind of learning the job. I started primarily in the city of Chelsea, Everett, Malden, Somerville, up there. And then after a little while, I got my feet wet in the 911 side. So I was running BLS.
All right, StreamYard, stop it.
Why do you have such an interest in being a first responder at a young age?
I kind of grew up in a first responder household. My father was a firefighter in a local town. So we spent kind of a significant amount of time at the station when he was on shift. It's just kind of how I grew up, kind of learning the ins and outs of public safety. That's just kind of how I came to be interested in the profession, and then I took it from there. So
I want to take us back just a little bit. When you first became interested in training to be a first responder, did you share with us your first training was as an EMT?
yes, sir.
Can you share a little bit with the jury what that entails?
So to become an EMT, like there are two sides of EMS, and then there are two sides of providers. There's EMT basic, and then there's paramedic. To answer your question, sir, to start as an EMT, it's about a 4-month process. You take classes. I believe mine was Tuesday, Thursday, every other Saturday. Learning just anatomy and physiology, basic pharmacology, and kind of how medications interact with the body and different disease processes. From there, you start learning basic interventions, backboarding, C-collars.
As part of your work in learning to be an EMT, you active in the field?
The initial training is, that's mostly classroom based, but once you sit your national written test and you're able to pass all that and pass practical, then you're able to progress into the field.
And did you succeed through the EMT training?
Yes, sir.
At that point, did you decide you wanted more training? You wanted to proceed through the profession?
Yes, sir. So after a little while, I worked for about 1.5 years in the field and decided that I genuinely enjoyed the work that I was doing. I then made the decision to progress to the paramedic level. That's a significantly more challenging academic portion. And
can you briefly share with us a little bit of the training that you needed to complete to be a paramedic?
Yes, paramedic training is about, I would say, generally takes people about 2 years to complete. There's about 1 year of classroom. It delves far deeper into not only diseases, but how they interact with multiple body systems, multiple different treatment modalities that we can pursue, multiple different interventions, a whole host of medications, far more medications than a BLS. As a paramedic, I have a much wider range of drugs that I would be able to select to treat.
Training and got this experience, did you ultimately become employed by the Canton Fire Department?
Yes, sir.
What did they hire you as?
They hired me as a firefighter paramedic.
And so you were both a firefighter and a paramedic?
Yes, sir.
Does the Canton Police Department, in their units, do they include paramedics and firefighters in the same division?
The Canton Police Department or the Canton
I'm sorry, the Canton Fire Department.
Canton Fire Department, the vast majority of the employees of the Canton Fire Department are paramedics. I believe there are I want to say 5 EMTs, but now as a requirement to occasion.
So we go to work as a different night.
So we would cross-man trucks. We were always fire suppression personnel, but we were also cross-trained as paramedics. So for example, if a fire call were to come in the town of Canton and I was assigned to ambulance 1 for the day, I would take all my equipment off ambulance 1 and I would transfer it to ladder 1. And then we would take ladder 1 to the fire call and operate as fire suppression personnel. If a medical call were to come in, I'm assigned again to ambulance 1. Then we take on the role as EMS. I take my paramedic skills and put them to work in the town on ambulance 1.
Let me ask you one more background question about how the Canton Fire Department works. When there's a call, an emergency call, is an ambulance sent with other vehicles or alone to the call?
Yes, sir. It's typically the engine of that district and the ambulance of that district. Depending on call volume, that can change. But if all is not to use the word quiet, it's kind of a taboo word, but if all is,
Don't use that word.
Everybody's in quarters and there's a dispatch in District 1, it'll be Canton Engine 3 and Canton Ambulance 1, and they go as a unit together.
Mr. Nuttall, I want you to take us back, if you would, to the early morning hours of January 22nd, 2022.
Was it snowy?
I want you to bring us a little bit before 6 a.m. Do you remember what you were doing?
Yes, sir. So that particular morning, I arrived at work earlier than I normally do. There was inclement weather that morning. So I left earlier than normal just to get in before the roadways got particularly difficult to travel and to relieve anybody that may need to get out if they needed to get home before the roads got particularly bad. I arrived just before 6 a.m. I was walking in. I was assigned to ambulance 1 for that oncoming 24. I was scheduled to be there at 8 a.m.
Could you share with us a little bit about how the weather was as you arrived around 6 a.m.?
Oh, good Lord.
It wasn't great. I was driving. It's about a 35-minute ride for me to get to Canton. The roads were starting to they weren't great. They had been treated, but they weren't pristine. The wind was starting to pick up. The snow was starting to come down a little heavier, which is the reason that I left at the time I did.
And so I may have misspoke. January 29th, 2022, that morning, around 6:04, did you hear a tone or did you hear an alarm?
So the tones went off right as I entered the building.
Tell us what a tone is.
So the tone is the emergency alert tone. In the town of Canton, we have 3. We have 1 for fire, we have 1 for investigation, and we have 1 for EMS. The EMS tones went off and the lights came on. Whenever the tones go off, the lights come on as well. I was just walking into the building when the tones went off and the lights came on.
And is there information that accompanies the tone, information about the call that needs response?
Yes. So after the tones had cleared, there's an overhead dispatch, which is our dispatch center, communicates to us before we get in the trucks and on the air responding, basic nature of the call. In that particular instance, we were dispatched to an unresponsive male in a snowbank with no real further information to follow up on.
So what do you do?
So as I said, I arrived pretty early that morning. But hearing that dispatch and that nature of the call, those typically tend to be more involved, both personnel-wise and work-wise. The crew that was working that morning was getting on the truck, and it was firefighter paramedic Anthony Flamati and firefighter EMT Matt Kelly. Matt Kelly has since become a paramedic, but at the time he was an EMT. So off the bat, that crew, not to say that they were at a disadvantage, but paramedic Flamati was the only paramedic on that ambulance.
What did you do?
So I made the decision. I checked with the shift commander, and I jumped on ambulance 1 to just give a second set of hands as being a paramedic myself, just being able to hopefully help if there was any advanced interventions that needed to be done or needed to be performed.
What
And
happened?
just a second set of hands.
What happens next?
So I got in the back of the truck. I was actually still in civilian clothing at the time because I had just walked in the door. So I got in the back of ambulance one in the patient compartment. The other two gentlemen were up front driving to the scene. I actually had to don my turnout gear because, again, I was in civilian clothing. I wasn't quite ready to go. So I had to put all my structural turnout gear on and then my Canton Fire jacket. Once I was sufficiently dressed for the call, I started prepping all the gear that we might need for a call such as that, for an unresponsive male in the snow. In this case, it was our first in bag, our airway bag, and our cardiac monitor. Everything was all together. They were all in 3 separate bags. But on the way there, I just got in. I didn't know how their night had gone. So I just took a real quick look at everything just to make sure everything was there and everything was exactly how it needed to be. So I was able to just grab all 3 bags, put them on my person, and get ready to, so as soon as the ambulance was on scene, just step off and go to work.
Not knowing much information about what you're going to confront, what goes through your mind as you prepare before you get off the ambulance?
Just basic scenarios. I mean, again, unresponsive male in the snow could mean several things. Not having much to go off on the dispatch was, it left much to be desired in terms of what we might need. So in gathering all the equipment together, it can kind of cover all the major bases, if you will, in terms of what we were expecting to meet once we got on scene.
How was your focus before you get off the ambulance?
I was ready to go. A dispatch like that, any unresponsive male in the snow, it can kind of up the level because you just don't know what you're walking into. You know, it could be anything.
In the back of the ambulance, you can't see outside. Could you tell anything about the weather conditions based on the way the ambulance was moving?
Again, being in the back, as you noted, it just seemed to be taking a little bit longer than normal. I really had no visibility at all. Like I said, I was in the patient compartment. It's very limited visibility in the back, and it's limited visibility. There's like a peephole that's maybe foot and a half by foot and a half to kind of peek up front. But
Peter traded.
again, I was so busy getting everything together, I really didn't notice, but I did note it took a little bit longer. We were going not slow, but we were going cautiously.
When the ambulance finally stopped and the doors open, tell the jury what you see.
So as I mentioned, I had the 2 bags and the cardiac monitor. So 3 pieces of equipment with me. And I stepped out of the back of or the side of the truck. There's a back compartment. There a back door and a side door. And I immediately noted wind hit up. I could hear like a distant screaming off in the distance. Wasn't exactly sure where it was coming from.
What was the visibility like?
It wasn't great. It was still dark out. The sun had not come up yet. The snow was coming down, as I said, heavily. And it wasn't great all around.
Was it cold?
It was cold. Yes, sir.
And so when you hear the screams, what do you do next?
I started making my way kind of towards the sound, following the sounds. I couldn't see anybody yet. So I just kind of followed the sounds. And then once I was able to get around the side of the truck, that's when I was able to see a group of 3 individuals with Canton Police. And I started making my way over to them to see where the patient might be located and what was going on.
As you get closer, tell us what you see.
So as we approached the scene, as I said, there were 3 individuals, and Canton Police were on scene as well. And then there was what appeared to be a human figure laying supine in the snow. I'd say about 6 to 8 feet, kind of where the sidewalk met the front lawn of a residence.
What does supine mean?
So that he was laying on his back. From there, I made my way directly over to that individual and started checking for signs of life.
How do you check? Do you get close? Do you get down on the ground?
Yep. So I knelt right at his head. Typically, to check for any signs of life, it's just as you see in TV or anything like that. You check the carotid pulse, and you check for any signs of breathing or anything like that.
Where's the carotid pulse?
So the carotid pulse would be right in the neck. Just real quick, 2 seconds, you can check either side. They're on both sides. Those are the strongest pulses that you can grab quickly. So I just real quick went right to that gentleman. Like I said, I looked for any signs of breathing. I found none. I checked a carotid pulse, and I found none.
How was his skin to the touch?
He was very cold to the touch.
He wasn't warm?
No.
So after you touched his cold skin and you felt the carotid artery? Is that how you
Yes,
call
sir.
it?
Carotid artery.
Did you come to any initial quick assessments or conclusions in your mind?
So I found, like I said, I checked for signs of life, the carotid, the signs of breathing. I found none. From there, we had ascertained that there is no signs of life. As I was checking that, the other two individuals on the ambulance came and met me, and they began doing the same thing just to check. I mean, sometimes you can look and you can miss. So the other paramedic, Anthony Flamati, started checking my work, and then we kind of went from there. But I found no signs of life in my initial.
So firefighter paramedic Flamati arrived to this person after you did?
Yes, sir. I was the first one to actually put hands on the individual and check for signs of life.
Did you later learn the name of this man?
I did.
And what was that?
John O'Keefe.
After you found no signs of life for John O'Keefe, did you get up and go to speak to anybody?
I did. So as being a second set of hands on the call, it's really not my call, like in terms of treatment modalities and how we want to progress. So after I found no signs of life, I kind of got up to kind of look around real quick. I went over to the individuals, the three individuals that were there, and just said, "Hey, I have found no signs of life. We're gonna see the next steps." And as I was saying that, that was when Anthony Flamati, who is the lead paramedic on this, made the decision. This is a workable cardiac arrest.
Let me ask you two questions. The first is, as a paramedic firefighter, are there times when you're the lead paramedic on a call?
Yes, sir.
And so it changes call by call, but this one was firefighter or paramedic Flamati's lead?
Correct. He was the lead paramedic on this call.
There are other times when you're the lead and firefighter or paramedic Flamati is on your crew and you lead?
Yes, sir. So we typically switch off. We'll do one, and then once my rotation is complete, we'll do the next one. So it's patient for patient, typically.
When firefighter paramedic Flamati called you back and said it was a workable situation, can you explain to the jury what that means?
Yes. So in medicine, there is a term that is, you're not dead until you're warm and dead. Meaning your core temperature, your core body temperature has to be within normal limits for it to be considered a futile attempt at resuscitation. Noting that, Tony, the other paramedic, Tony Flamati, realized that this gentleman was very cold to the touch and that this was now a hypothermic cardiac arrest, or a cardiac arrest in a hypothermic setting, which means as providers, we have a duty to initiate life-saving measures, CPR, ventilation, and continue those efforts until we get him to a hospital and a physician is able to take over and they are able to monitor his core body temperature for a certain amount of time.
I want to ask you about a term you used. You said a hypothermic situation. As a firefighter paramedic treating a patient at the scene, you're not diagnosing hypothermia, are you?
No, sir.
So you're not making a medical diagnosis. You're just saying it's a hypothermic situation because of
the condition. He was in the elements. We didn't know how long. So taking the fact that he is extremely cold to the touch and he had been outside for an unknown amount of time, that quantifies it to us as a hypothermic arrest or a cardiac arrest in a hypothermic setting.
Is there anything about Mr. O'Keefe's fingers or hands or his face that gave you any indication if he had been there just recently or had been there for a while?
His fingers were quite cold. They were not well perfused at all. They were very, very.
Mean? I don't know. What does not perfused mean?
Sorry, there did not appear to have been any blood flow at all. Just because he was, again, presumably being outside, his fingers were very, very white. They were very stiff. which can be signs of hypothermia and frostbite. And again, touching the neck. So typically when you get cold, you kind of work back from your extremities in. So again, I noted his fingers were quite cold, but also when I checked his carotid, his neck felt quite cold as well. That just kind of tipped us back further down the road of a hypothermic cardiac arrest.
I see. When firefighter Flamade called you back,
Yep.
Where did you go exactly?
I went, so when I was told that this is what we're doing, I turned around and I went right back to where I previously knelt, which was right at Mr. O'Keefe's head. And then I took over the ventilation aspect of a cardiac arrest. So I was in charge of the airway. So I began giving him positive pressure ventilations with a bag valve mask, which is just a glorified balloon that you can push oxygen through and down into your respiratory tract to get oxygen moving. While I was doing that, I believe firefighter EMT Kelly had begun CPR.
So is this fair to say it's a team effort?
Yes, sir.
A coordinated effort?
Very much so.
And depending on where you're placed, whether in the back of the ambulance or driving or leading, does everybody have an important role to play?
Yes. Yeah, we work in conjunction with each other. Typically, the most well-defined roles in a cardiac arrest in EMS is your airway monitor, which was myself in this situation, and then your cardiac and medication administration, which is, that would be Anthony Flamati, that would be Tony. Just because of my position at the head, I just took over the ventilation aspect, and that was where I remained throughout the call.
You said you went back to try to help Mr. O'Keefe, and you were giving, helping at the airway. Do you have to actually get on the ground to do that?
Yes, sir. I was kneeling at his head.
While you were kneeling at his head, well, let me ask you a more of a background question. Is it helpful to get information about the history of the person when you're trying to treat them when you happen upon a scene and you don't know the history?
Yes, sir. Very much. Getting information on medications, history, and allergies is our top priorities in any call, not even this call, just really any your run-of-the-mill fall or chest pain. That's typically the first questions that we ask. What medications are you on? What medical history do you have? And do you have any allergies? The medical history is important because if you've had heart attacks in the past, or just using a generalized example, if you've had heart attacks in the past, does this feel like a previous heart attack? It kind of gives us something to go off of.
As you were nailing, I want you to take us to that moment. As you're nailing, trying to help Mr. O'Keefe, did you have a chance at any point to look up?
I did.
And when you looked up when you were trying to help Mr. O'Keefe, can you tell us who you saw?
I saw a middle-aged middle-aged female with blood on her face. And I, real quick, as I was in the process of providing ventilations, I said, do you know this person?
The person that you looked up and saw that was standing over you with blood on her face, do you recognize that person in this courtroom?
Yes, sir.
With the court's permission, sir, could you point out that person that you looked up and saw?
In between Mr. Jackson or next to Mr. Jackson.
I see. So when you looked up and saw that person and asked about any background, what did she say to you?
I hit him.
He
How
didn't say
clearly
that
do you
in the
remember
last
her
trial,
words
did he?
saying to you, I hit him, I hit him, I hit him?
I remember it very distinctly.
You've been to a lot of calls over the years and since.
Yes, sir.
Would you say hundreds or thousands?
Did he say
Thousands.
that in the last
Do
trial?
you remember all of them?
I remember aspects of various calls, but not all of them, no.
Do some stand out more than others?
Yes, sir.
Did this particular moment stand out more as compared to your typical or most calls that you've been to?
It did, just because of the setting.
Okay.
I mean, it was the weather, it was the unknown factors, and it was the attempting to try and get information and not really being able to glean anything from that.
After the defendant said to you, I hit him, I hit him, I hit him,
Yeah, I
did
didn't.
you ask any follow-up questions?
I really didn't get a chance to, because following that, the individual just kind of walked away or just kind of went in a different direction. I wasn't able to ask any follow-up questions.
Have you ever received any police training?
No, sir.
Are you a police officer?
No, sir.
When you're helping a patient, do you have any interest in detective work?
No, sir.
Do you have any interest in investigating potential crimes?
At that time, in this particular instance, because I was at the airway, that is a pretty critical aspect of a cardiac arrest. I was stuck there. I couldn't get up and kind of follow up on that at all. I was there doing that ventilation.
Is it your job to investigate cases or simply to get information to help treatment?
Just the information.
When you go out as a firefighter paramedic, do you have a purposeful cause?
Yes, sir.
And what is that?
To save lives.
And is that your only focus?
In this instance, it was attempting to restore circulation and breathing.
At some point with your colleagues, did you lift Mr. O'Keefe from the ground?
We did.
When you lift him, what do you put him on?
So we put him on, it's called a scoop stretcher. It's basically just a hard plastic moving device with some seatbelts on it, just to get the patient up and onto the stretcher. And then from there, we can move from the stretcher to the ambulance.
After you lift him to the stretcher, tell us what happens next.
So we put Mr. O'Keefe on the scoop stretcher and we were able to get him onto the stretcher itself and then off to the ambulance. From there, I maintained my role as the airway individual on this call. So we made our way to the ambulance. I got in the tech seat, which is directly behind where the stretcher locks in. So I had access to the airway again. I was continuing to provide positive pressure ventilations to Mr. O'Keefe, and we had put in an OPA as well, which is just a plastic hook, if you will. It just keeps the tongue from falling back into the airway so we can continue to provide positive pressure ventilations. Once we got him in the truck and we continued that effort, we set up a suction system and we prepared to intubate Mr. O'Keefe. We prepared a suction system just because as I was ventilating outside of the ambulance, there were some secretions in the airway that I could see, and you could get secretions kind of getting like bubbly and stuff like that. So we knew we were going to need to suction him. So we got him in the truck. We really quickly suctioned him, and then we were able to intubate him successfully to definitively give him an advanced airway and give him better ventilations, get more oxygen into his system.
Now, you mentioned that he wasn't warm, he was very cold.
No, he was still very cold.
What does the team do to try to assist with that?
The most basic thing that we did, we turned the heat on as high as it would go. We also stripped all of his clothing off, just getting all of that wet clothing off of him. I didn't really have a role in that particular part of it, just because once you're on the airway, that is kind of yours. Nobody can breathe for him. So every time I squeeze that bag, he gets a breath. So I'm kind of tied to that airway for the duration of the call.
So when your colleagues are stripping the clothes off him, is your attention on the clothes or more on the airway in your job?
No, I'm maintaining the airway. If an endotracheal tube is dislodged for whatever reason, it is typically more difficult to get one in. So the integrity of that tube staying where it is and not being dislodged, that is another key aspect of airway management.
As you're doing that, do you notice what anybody else, any of your colleagues are doing to help?
Like I said, they were working on clothing removal. I believe they were also getting intravenous and intraosseous access on this individual to begin medication administration. But again, I was quite focused on that airway, just making sure that it was maintained and we didn't lose any tube. We didn't lose any end-tidal CO2, which is just another monitoring device that we use to confirm that tube is in place.
How quickly do you get to leave the scene and start moving towards the hospital?
I honestly couldn't give you an accurate estimate. It didn't seem to be out of the ordinary realm, though. We were able to move within the flow.
In addition to Mr. Keefe being very cold, did you notice any other injuries on him?
So I noted that he had a hematoma right above his right eye.
Could you explain to us what that is?
Yep, it's just, for lack of a better term, it's just a big egg. He had a pretty good bump over his eye.
And you said his right eye.
Yes, sir.
Did you know how that hematoma was caused?
No, sir.
No idea?
No.
In addition to the hematoma above his right eye, what other injuries did you see?
There were also several scratches on his right arm, just below his shoulder and traveling down his right humerus. They terminated right about his right elbow, just above it.
Those scratches, have you also described them as abrasions?
Yes, sir.
Is there any difference in your mind, difference between scratches and abrasions?
Nope. These were they were deep and they were not bleeding, but they were notably deep.
Did you ever describe it as furrows?
I did.
And in describing those scratches, do you have any idea how they were caused?
No, sir.
Okay. And did you notice any other injuries on Mr. O'Keefe?
No, sir. Those were the kind of the only ones that we noted. As I mentioned, we suctioned a little bit of blood out of the back of his airway as well. I believe it was blood, mucus, and saliva. But those were the extent of the injuries that I was able to note.
Did you notice anything about the back of his head?
Actually, yes, I did. I apologize. There seemed to be a little bit of matted blood around in his hair around there. Really didn't see anything too obvious at the time. He was also placed in a cervical collar as well, following intubation, and that was kind of there just to maintain his cervical spine. But there was, like I said, there was noted to be a little bit of dried blood on the back of his head.
At some point, did you finally make your way with Mr. O'Keefe to the Good Samaritan Hospital?
Yes, sir.
And just share with us what happens when you get there.
So after we got there, we handed off care to Good Samaritan Medical's physicians and ER nurses. We were able to give a report to the physician of just basic what we've done, what we've given for medications. In my case, what he was intubated with and how he was being ventilated, how well he was being ventilated, and any other further pertinent information. Typically, we noted that Tony was the lead paramedic, so that is typically he kind of holds the room for a minute when we get in there and gives a big rundown, and then we back off and let Good Samaritan take over.
When the defendant told you that she hit him, did that have any significance to you?
No, sir.
Did it reconcile with the injuries that you saw before you that Mr. O'Keefe was suffering from?
No, sir.
And so at that point, was that information insignificant in light and perspective of your care?
Sustained.
Okay. What role did that information play in your care after the defendant told you she hit him? How did that contribute or not contribute to what you were doing?
It really didn't help at the time. Again, I wasn't able to chase anything down from that. I just kind of took it, noted it, and moved on with my aspect of the cardiac arrest.
Okay. Have you had an opportunity at any point to see any video of that morning taken from any source, police car, dash cam?
Yes, sir.
All right, I'd like to introduce a video stream.
So this will be in evidence. There are agreements with some of the evidence already?
I believe there's no objection, but I don't want to speak for the defense.
Okay, thank you. Yes, you can show it.
And for the record, if I may note, this is Cruiser 683 Stream 2. I'm sorry. It is Cruiser 683 Stream 2. I'm going to ask to play a portion of it that's relevant to Mr. Nuttall. Ms. Gillum, if you would please move to 6:11 a.m. Please stop the video. Mr. Nuttall, do you see the red lights reflecting on the left?
Yes, sir.
Do you know what those red lights are?
Presumably, those would be ambulance 1.
Yeah, so not what you presume. Do you know what they are, sir?
And those are the lights for ambulance 1.
Do you see the weather conditions as it's depicted on this video? How it appears on this video?
That is the same.
When you look to the left, you see a straight line about an inch or two from the left of the screen. Do you know what that item is?
Sorry, sir. Repeat the question.
If you look to the left of the screen,
Yep.
you'll see a straight item from the bottom halfway up the picture. Do you know what that item is?
I
On the
believe
video?
that's a flagpole, sir.
Do you see a little bit of movement of bodies near that flagpole?
At the present time, no.
Okay. Could we continue to play, please?
Yep. There they are.
Could you stop, please? Did you see the first person in line now behind the person with in front of the person with the blue? That
I'm sorry, sir. Can you back it up like 10 seconds?
certainly. Keep going, please. Do you know who that person is?
I believe that's me, sir.
Okay. Could you please continue? Is this your first assessment?
Yes, sir. This is ascertaining any signs of life or breathing.
Is that you approaching?
Yes, sir.
Oh
Could you
my
stop, please?
God.
After informing you return, is that after firefighter Flamati called you?
So right after that, when I turned around, that was when Tony said, "Hey, we're working this."
Which one's
Please
McLaughlin?
continue.
Is that the girl?
Stop, please. And do you see a person come over to where you are?
Yes, sir.
Is it at that point or another moment when the defendant said, I hit him, I hit him, I hit him?
It was right there, sir.
Could you continue, please?
Wait a minute.
Could you stop for a
He was
moment?
down by his head when she said
There's no voices or noises from people coming through that audio. When you were there that night throughout the event, was it silent or were people speaking? Did you hear people speaking?
There was, as I noted when I got out of the truck, there was quite a bit of screaming. It was quite chaotic. The wind was also a factor, but there were people around. They were speaking within themselves too, but there was screaming, there was wind, and there was different side conversations as well.
And when you were working on Mr. O'Keefe, were you having conversations with your colleagues?
Yes, sir.
They're not picked up on the audio?
No, sir.
Please continue. Sir, are you still at the flagpole?
Yes, sir. I'm kneeling at the head of the patient.
so he heard her say she was standing over by the car and he heard that all the way over there. She was the EMT that was friends with Caitlin. That got grilled so hard about being friends with Caitlin, and she kept saying, "No, I'm not friends with her. We just went to high school together." I knew her. I knew of her from high school, and they were on the same track team and went on trips together and baby showers and all that crap.
Are you included in that group of first responders?
I am not, sir. I have actually exited to the side with the bags. I believe I'm entering the ambulance at this point.
Okay. Thank you. We can conclude the viewing.
Which I don't wish that on anybody.
With the court's permission, I'd like to approach and show a few exhibits to Mr. Nuttall. They've been shown to the defense.
Yes,
Should have
Thank
told
you.
the
May I
truth.
approach?
yes.
Thank you.
Is she on the witness list? Where's my phone?
Going to show you a photograph.
Yes, sir.
Sir, do you recognize what's in that photograph?
Yes, sir. Those are the scratches on Mr. O'Keefe's arm.
Does that appear the same as when you saw his arm that morning, or is there any differences? And if there's any differences, can you share them with us?
That appears how they were to me at the time of the incident.
Okay. May I approach again, Your Honor?
Yes.
I'd like to introduce this as an exhibit, please.
Okay.
I'm going to hand you a.
Hold on.
I'm sorry.
Thank you.
Pardon me, Your Honor. May we publish to the jury?
Yes.
Is that the photograph you just identified on the screen?
Yes, sir.
Showing you a second photograph, I'd like to ask you some questions about it.
Can we take that one down, Mr. Brennan?
Yes, of course.
Please, Ms. Gilman.
Thank you. Does that photograph, do you recognize that area?
Yes, sir.
Is that the same or substantially the same area where you helped try to treat John O'Keefe?
Yes, sir.
Does that look to be a fair and accurate representation of the area?
It does.
With the court's permission, I would introduce this as an exhibit, please.
Okay, and there's no objection to any of these three?
None.
Okay, yes.
Thank you.
Thank you.
With the court's permission, could I publish exhibit 2?
Yes.
And sir, that's what you recognize as the area where you were helping to treat John O'Keefe.
Yes, sir.
I've left one last photograph in front of you.
Yes, sir.
And do you recognize that?
I do.
Tell us about any differences between when you were there and what you see in that photograph.
The street appears to be plowed. There's bare pavement. The weather conditions are significantly better. It is also daytime.
If we could take down that exhibit 2, Ms. Gilman. May I approach, Your Honor?
Yes,
I would move to introduce this as exhibit 3.
all right.
With the court's permission, I'd like to publish exhibit 3.
Sure.
Is that the photo you just identified?
Yes, sir.
Okay, we can take that down. Thank you. Thank you, sir. I have no further questions, Your Honor.
All right. Jackson?
Good morning, good afternoon, Firefighter Nuttall.
Good afternoon, sir.
Nice to see you again.
You as well.
Before your testimony this morning, how many conversations had you had with any member of the prosecution team in anticipation of your testimony today?
I believe it was 3, sir.
When were those?
I could not give you dates off the top of my head.
Give me a time frame within the last 3 weeks, within the last 3 months, last 3 days.
Within the last 3 weeks, I believe one the week after that, and then one last night.
One
Last night.
last night. What you did discuss, let's take them in order. First of all, who'd you meet with 3 weeks ago?
I met with Mr. Brennan and his staff.
And when you say his staff, who else?
I honestly couldn't tell you, sir.
Mr. Lally?
No, sir.
Male, female?
One female, one I believe state trooper.
Okay. Had you ever met State Trooper Tully previously?
Yes, sir. Actually, I believe that was him.
It was State Trooper Tully?
Yes, sir.
Whom you've met with several times, correct?
Prior to that, I believe only once or
Okay.
twice.
He was the one that he has formally interviewed you previously, correct?
I believe he arranged the meetings with Mr. Brennan. But
Okay.
Beyond that, I can't speak to.
What did y'all discuss 3 weeks ago?
The first meeting, going in order, it was mostly just kind of an introduction. I had not met Mr. Brennan yet. I really didn't know him. So it was mostly that, and then just kind of seeing where we were at with testimony, going over previous testimony and in that sort of realm.
Prior to today, how many times have you testified under oath concerning the incident on January 29th, 2022?
Once at a grand jury hearing and once last year.
All right. As a matter of fact, last year in this courtroom.
Yes, sir.
Okay. Did you look over your testimony at the grand jury 3 weeks ago during that meeting?
No, sir.
What about the testimony from last year?
We did go over the testimony from last year. Yes, sir.
Were there any issues that Mr. Brennan or anybody else in that meeting brought up concerning any of your testimony?
There was just a question of how many times the I hit him came up. It was 3 times.
And were you advised that that's not what you said at your testimony last year? Said it
No,
was
sir.
2 times?
What was that?
You said it was 2 times last year?
I honestly can't recall, sir.
Okay. But you just saw that, or you just read that and went over that 3 weeks ago.
I believe so, sir. Yeah.
But you can't remember, as you sit here today, just 3 weeks ago, what y'all discussed in terms of how many times you previously testified that you heard the phrase, I hit him.
So previously testified possibly to 2, but it was 3.
Okay. Your memory is clearer now than it was, for instance, a year ago when you testified.
Repeat that?
Sure. Your memory is clearer now as you sit here that it was 3 times you heard that than it was a year ago when you testified that it was 2 times.
Yes, sir.
Okay. Does your memory get better with time generally? Your memory. I'm not talking about the royal you. I'm talking about you.
In certain settings, I mean, there are certain things about different aspects that I recall better than others.
Okay. And does your memory tend to get better or does it fade over time? That's my question.
It can fade over time, but it depends on the context.
But in this case, you're telling this jury that your memory is better now than it was a year ago when you testified about the exact same circumstance, correct?
Yes, sir.
Okay. You then met about a week after that, which would be 2 weeks ago.
Yes, sir.
Who'd you meet with then?
The same group.
And what did you discuss at that meeting?
Again, just prior testimony, and that was really the gist of it.
And tell me the specifics of the prior testimony that you.
Again, it was the how many times we had talked about saying I hit him. Again, it was 3 times, and then there was also the video that was just played, but was played for me.
If I'll take the video in just a second. If y'all had met 3 weeks ago and you indicated to Mr. Brennan that it was actually 3 times, not 2 times that you heard the I hit him, why did you need to discuss it again a week later to verify the 3 times versus 2 times?
Not sure, sir. That was just the way that the conversation went. And I just, again, repeated what I said and what I remember from that morning.
Well, tell me about that conversation. Did Mr. Brennan say, really sure that she said it 3 times?
It was that morning what was said to you. And I said, I said, I hit him, I hit him, I hit him. That was how it was that morning, and that was how I remember it.
Okay. And did Mr. Brennan say, well, that's not considered how you testified previously concerning the number of times you heard the I hit him phrase?
Yes, sir.
He did say that.
He wanted to, he acknowledged that I had said it twice, or again, as I mentioned, it was said 3 times to me.
So now you do remember last year that you only said it, you only said that it was repeated twice.
One more
Correct?
time, sir.
So now you do recall that last year when you testified, it was inconsistent with how you're testifying today. Let me put it that way. Correct?
I believe I said I hit him twice on the stand last year.
Right. And if you're saying I hit him 3 times instead of twice, that firefighter Nuttall is inconsistent with your testimony today. Correct? You
Yes,
agree
sir.
with that?
But that is how it went that morning, though, sir.
Okay, that's not my question. Let me see if I can do it again. So I'm asking you, if you testified last year,
Yes, sir.
that you heard the phrase twice,
Mhm.
and now a year goes by and you're testifying in front of this jury this year that you heard it 3 times, those 2 statements are inconsistent with one another, correct?
Yes, sir.
Okay. Did you talk at the meeting 2 weeks ago about any other inconsistencies with your testimony?
Not to my knowledge, sir.
Well, you were there. You
No.
say not to my knowledge, meaning,
No, sir. We did not.
okay. So it was just about the number of times that you heard the phrase, I hit him, correct?
Yes, sir.
All right. You cleared that up in the 2 meetings, 3 weeks ago and 2 weeks ago. What did you talk about last night?
Mostly just making sure that everything was as it had been. I mean, and by that, I mean, it was 3 times, and that we were continuously making sure that everything was the way that it happened that morning.
Everything was the way that Mr. Brennan wanted it to be.
No, sir. The way that it was in, I remember it, and I recall it happening.
Okay. So he asked you 3 weeks ago about how many times you heard that phrase.
Yes, sir.
You changed your testimony at that time and said it was 3 times instead of 2 times. We agree on that, correct?
Yes, sir.
Then he called you a week later, or met with you a week later, and again reiterated, making sure you stick with that testimony that it's 3 times, not 2 times, correct?
Yes, sir.
And then last night he called you just to make sure one more time you're going to stick with that testimony that it was 3 times, not 2 times, correct?
Yes, sir.
Hold on just a second. May I have just a moment, Your Honor?
Yes.
Okay. And when you talked last night, did you assure Mr. Brennan, nope. When we come in tomorrow, I'm certainly going to say it was 3 times, not 2 times.
No, sir. I told him I would tell my recollection of that morning.
Okay. And did you tell him that what my recollection is, I'm going to tell the jurors it was 3 times that I heard it?
That was what I heard.
Okay. Did you tell him that's what you were going to say today?
No, sir.
You didn't?
I told him I was going to tell him what I remembered from that morning.
Which was what?
I hit him.
Which is how many times?
3 times, sir.
And that's inconsistent with what?
I believe a year ago.
Okay. Now, you also talked about, I want to get back to the other thing that you talked about. You said that at some point, either in the meeting 3 weeks ago, the meeting 2 weeks ago, or the meeting last night, you were shown a video.
Yes, sir.
Which one of those meetings were you shown a video?
I believe the second one.
Okay. Were you shown the entire video?
No, sir.
Just the clip that we saw?
Yes, sir.
Okay. What did y'all talk about in relation to that video?
Mostly nailing down who was who in that video.
Okay.
Being the other personnel on scene, where I was, and that was about it.
He showed you the clip that you showed. He showed you the clip that you just seen on direct examination, correct?
Yes, sir.
Did you tell him where you were?
Yes, sir.
Did Mr. Brennan ask you to define exactly where it was that you supposedly heard this phrase, I hit him?
No, I was able to give that to him, sir.
Okay. And what you told him was that moment when you see my client walk over sort of to the left of the screen, correct?
Yes, sir.
And you defined, that's the point at which she said, I hit him, I hit him, I hit him.
Yes, sir.
And that's in response to your question. I want to make sure I'm clear about this. You asked Do you know him?
Yes, sir.
And she repeated the phrase 3 times, I hit him, I hit him, I hit him.
Correct.
Okay. We'll talk more about that in just a second. Did Mr. Brennan ask anything else about that specific video?
No, like I said, he kind of asked me to point out different individuals on the scene, and that was really the extent of it.
You saw that same video last year when you testified, correct?
No, sir.
You didn't see it last year?
Not to my knowledge, no.
In preparation for your testimony last year?
I did not.
Did you see it before your grand jury testimony?
No, sir.
Okay, so this is the first time that you've seen it.
Yes, sir.
And you were able to establish for Mr. Brennan exactly when it was that you believe you heard the statement based on your view about 2 weeks ago of that video.
No, that was the way that I remember it.
Right,
That
not
morning.
a trick question. My question is much more simple. You were able to establish after 3.5 years now exactly where you were and where Miss Reed was and who else was around at the time that you believe you heard those 3 statements in order. I hit him, I hit him, I hit him.
Yes, sir.
Okay.
What was that about?
You testified
Faces.
last year as well that there is a normal protocol for removing clothing from a patient, and it's essential to just discard it and get it away from the patient so that you can concentrate on the life-saving measures that you're undertaking, correct?
Yes, sir.
That could be done you said in the ambulance, it could be done in a hospital, it could be done in situ out there in the field, correct?
Yes, sir.
But the point is you want to get as much clothing off of the person as possible so that you can assess that person's physiology.
Yes, sir.
It's not really a lot of care taken to preserve the clothing from an evidentiary standpoint in your view, correct?
And we're trained to try and, just to take example of a shooting, try not to cut through the entrance wound of the clothing.
Fair enough. Fair enough. I mean, when you're literally trying to save someone's life, your job is to get the clothing off and get it out of the way.
Yes, sir.
You're not sticking it in an evidence bag and sealing the evidence bag, things of that nature.
No, sir.
So it might end up on the ground.
Yes.
Right? Might end up with some debris on it.
Yep.
Might end up on the floor of the ambulance.
Yes, sir.
Could end up in the floor of the hospital.
Mm-hmm.
Or on the floor of the hospital. Is that right?
Yes, sir.
Okay. And if it's clothing, may well pick up debris from the ambulance.
Oh, yeah. Yes, sir.
Or the debris from the floor of the hospital or wherever.
Mhm.
Is that yes?
Yes, sir.
Okay. You testified previously at the grand jury in April of 2022, correct?
Yes, sir. I believe so, sir.
Okay. So this happened in January of 2022, that same year in the springtime. You testified at a grand jury, April 20th, I think it was.
Yes, sir.
Does that sound right?
Yes.
Okay, I want to take you back to that testimony for a second. You testified at that hearing that Mr. O'Keefe was, quote, dressed appropriately for the weather. You remember that?
Yes, sir.
All right. It was obviously well below freezing at that time.
Yes,
That night that you responded.
it was.
We just seen the video. It looks cold as hell, right?
It was chilly.
All right. The wind was howling.
Yep.
It was snowing. Is that right?
Yes, sir.
And you testified that John O'Keefe, quote, had a heavy coat on and possibly 2 other layers of clothing.
Yes, sir.
In April 2024, you reiterated your very specific memory of and you even called it a puffy heavy coat that he was wearing, which was then removed so that you could assess his injuries, correct?
Yes, sir.
All right. Not to get too colloquial, but a puffy coat is like, it's got down and stuff in it, right?
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes, sir.
Okay. Pretty distinctive article of clothing.
Yep.
And you testified last year that Mr. O'Keefe was wearing that clothing, which you had to remove or somebody had to remove in order for him to be properly assessed.
I did testify that way. Yes, sir.
Okay. And you mentioned that your memory of that big, heavy winter coat was as clear as your memory of other specifics in this case, correct?
Yes, sir.
I asked you that exact question, didn't I?
You did.
And I said, your memory of him having that big puffy coat on, which stood out in your mind, was just as clear as the other specifics that you've testified to about the case,
Yes, sir.
about that night. And turns out you were completely wrong about his clothing, correct?
Correct.
Matter of fact, he wasn't wearing a coat at all.
No, sir.
He wasn't wearing a winter coat, correct?
Nope.
He wasn't wearing a heavy winter coat, correct?
Correct.
And he wasn't wearing a puffy, heavy winter coat.
He was not.
Yet you testified that he was wearing all of that, and that was clear in your mind at the time.
Yes, sir.
Did Mr. Brennan bring that up during the meeting 3 weeks ago?
He asked about what I had meant when I said appropriately dressed.
So you did talk about something other than just the I hit him, correct?
Yes, sir.
When I asked what y'all talked about, why didn't you tell us that?
To be perfectly honest, sir, I did not remember until right now.
So your memory is fading even after 3 weeks.
Yes, sir.
Oh,
Got it. The fact is, well, let me ask you a different question. Did Mr. Brennan tell you what Mr. O'Keefe was actually wearing
No, sir. Actually, I believe you did.
last year, didn't I?
Yes, you did.
It's a short sleeve t-shirt and a little thin wool hoodie, right?
Yes, sir.
Wasn't wearing a hat.
No, sir.
Wasn't wearing, as a matter of fact, didn't even have a shoe on, correct?
Not to my knowledge.
And obviously, goes without saying, but I'm going to ask it anyway. That's not being appropriately dressed for the winter.
No, sir.
You indicated that you did notice certain injuries on Mr. O'Keefe's person.
Sir.
Once you got him back in the ambulance, obviously it's lighter, meaning brighter lights. You have more equipment in the back of the ambulance. You can better assess somebody's well-being, correct?
Yes, sir.
And you indicated you had a, quote, much better picture of what we were dealing with, correct?
Yes.
You noticed once in the back of the ambulance that he had trauma to the right side of his head.
Correct.
And as a matter of fact, when you were pointing at it, I'm doing that on purpose because you pointed to the right side of your sort of forehead above your right eyebrow, correct?
Yes, sir.
Okay. The majority or the worst injury that Mr. O'Keefe suffered was actually to the back of his head, which you indicated, you noted was quite matted with blood, correct?
Yes, sir.
I want to talk about the injury to the right side of his head as distinct from the back of the head injury for just a second. Before I get to that in detail, let me ask you, because I just sort of want to cover the bases. You noted the back of the head injury, correct? Is that yes?
Yes, sir.
You also noted the front right side of the head above the right eye, correct?
We did.
You noted some injury to his eyes. They looked blackened.
Yes, sir.
But primarily the right eye was blackened.
Yep.
And there was a golf ball size egg, I think you put it over his right eye, often called a hematoma.
Correct.
And you also noted when you got his shirt off that he had scratches along the right side of his arm. Is that right?
Sir.
You indicated on direct examination today that you believe those scratches ended where? Meaning from top to bottom? And I'm not using anatomically correct language. So from shoulder to wrist, where were the scratches that you noted?
There were several. As I noted, they were on his right humerus area.
Tell me what a humerus is.
The right arm.
Biceps.
Right about here.
Okay.
No, a little further, like between where your bicep and your tricep kind of meet. Right,
Got it.
Right about in there.
Okay. And what did the scratches look like?
They were deep. Infamously referred to them as furrows, but they were quite deep. You could tell that there had been some material removed.
Okay. Material meaning skin and flesh.
Yes, sir.
Okay. Some biological material.
infamously referred
Yes.
to
Yes,
as
sir.
And
furrows.
were they parallel? Meaning they were going in the same direction?
Yes,
With scratches below the arm as
there
well?
were. Yes, there were. They were not as significant as the ones in the upper arm, but they were noted.
Okay. And those were parallel as well?
Yes, sir.
And they look like scratches to you. That's how you describe them.
They did.
Last year, when you described those scratches, you curled your fingers up, exposing sort of the nails, and drew it across your biceps. Is that what you were using to describe what the sort of scratches looked like?
I just kind of used that as a landmark, to be honest with you,
Okay.
sir. It was just kind of how I quantified it in my mind.
Okay. But what you did was you did this motion.
Yes, sir.
As you said, there were furrows. And remember, there was an embarrassing moment for me.
Both of us, sir.
I couldn't understand the word furrow. because of the accent, right?
Yes, sir.
All right. Let's talk a little bit about the hematoma above the right eye for a second. That's basically damage to subdural blood vessels that causes acute swelling, right?
Correct.
And a very common cause of a hematoma over one's eye could be being hit or punched in the face. We talked about that.
There could be several causes for hematoma, such as that.
Obviously. I mean, it could be a golf club, a baseball bat, or it could be a fist.
It could be.
Okay. We talked about that last year. I asked you if the injuries that you saw on Mr. O'Keefe's face, including the laceration over his right eye, was consistent or inconsistent with a physical altercation, and you said it was consistent with a physical altercation as well.
Excuse me?
Objection to referring to past testimony before a question is asked.
So sustained.
Sure. Do you remember a laceration, in addition to the hematoma, about a 0.8 centimeter laceration over his right eye?
I do.
Tell me I'm using a word that maybe not everybody understands. I didn't understand it when we first started this thing. What's a laceration? What's the difference between that and a cut?
A laceration is they're basically the same thing. A laceration is just a deep cut.
Okay. So it's a parting of the skin.
Correct.
In other words, where the skin separates.
Yes.
And that can be from blunt force trauma, meaning something hits it rather than cuts it.
You can get
Sustained.
What was the
What are
objection?
some of the causes of lacerations?
a laceration, as you noted, blunt force, but you can also get a laceration from a slashing movement, from a stabbing. I mean, that is still a laceration.
What about a hematoma?
That is primarily caused by blunt force trauma.
Right. And the hematoma and the laceration were right next to each other, correct?
Yes, sir.
Okay. And you indicated last year, or let me ask you this way. Is that consistent or inconsistent with a physical altercation?
Objection.
Can you answer that?
I could not say, Your Honor.
Okay, next question.
Well, last year, you indicate you can't answer that. Last year, you did answer it, didn't you?
Objection.
So I need to see counsel at sidebar for just a minute.
Why can't he impeach him with his testimony? You can impeach with prior testimony. You can.
Mr. Nettle, we are going to let you take a break and come back and join us after the luncheon break. So this is
Sounds good.
the luncheon break. There's lunch here for you. I assume Tony is it here? Okay. There's lunch here for you. We'll see you in about a half an hour.
Did she say half an hour? That's not a very long break. Okay, well, we'll just talk since it's just a half an hour. The close up, I missed it. What? Did anybody see it? I missed it. What did he look like? Oh, it's not putting comments on the screen. Oh, there it goes. I missed it. What did he look like? Is Paul there? I didn't even look.
Just
Well, I guess I can. Or here, do that. Oh, do that. Come on, StreamYard. I'm doing too much. It's going to crash on me. Okay. Let's Oh, Paul is there. There he is. That guy? That's Paul. That is John's brother. And he has been such a jerk. Oh. She scared me. Did you see me jump? I tried to get you to go outside a while ago, girl. Come on. Come on. What? I didn't cook anything. I just turned it on, warm it up, and then I changed my mind. What do you want? I didn't cook anything. You gotta go potty? Come on. I didn't cook anything in it. I did. I warmed up the air fryer because I was gonna cook something in it, and then I changed my mind. So now, what? There's nothing in it. I've confused her. I changed my mind. I decided not to cook anything because I'm not hungry. I'm sorry. I'm sorry. Don't look at me like that. They can't go out for lunch at all? The whole entire trial? Yeah, he's suing Karen for wrongful death and C.F. McCarthy's and the Waterfall for over-serving. All of them, I think. Or maybe just for over-serving Karen. I don't know. And he thinks that she did it. Nope, it's Belle. She knows that, ooh, I know what I can make in the air fryer, and you will be happy, and it'll be quick. Okay, I'll go warm it back up. I'll warm it back up. Do you have to go potty? Do you have to potty? Go potty? Do you have to go potty? You better not pee in this house. No, she knows the good stuff comes out of the air fryer. And so I was going to make a baked potato, but that takes like 45 minutes. So I warmed it up, and now she knows that we're going to eat something out of the air fryer. But then I changed my mind and I turned it off. That bark was reminding me that the air fryer was on. She's smart. She knows. One time her water, because we have like a giant water feeder thing. Not a giant, but like it's like maybe a 4-liter thing. And it was empty one time. She got, y'all, this is the smartest dog ever. She got in the shower and looked up at the faucet, or at the shower head. Looked up at the shower head, looked at me. Looked up at the shower head, looked at me. I was like, oh, do you want water? And I went and I looked and her water was empty. I was like, you have got to be kidding me. I cannot believe that dog just told me that her water was empty by going in the shower and looking at the shower head. I could not believe it. Could have knocked me over with a feather. It's Paul. Paul's the one that's. Make sure I got this back on play. Because Paul's the one doing it. I shouldn't say this. I think it's bad the way they're treating the family of John, right? But he should have taken those kids. Those need a mother and a father to raise them. They don't need a single male. They would have been raised in a normal family atmosphere with a mom and dad and brothers and sisters, and it just would have been better. But no. So I don't know. I could, maybe I don't have all the information, but. And they said they considered it. Oh, we have music now. Yeah, she is. One time, you guys know the story about the Chihuahua and how my hand got bit and all that, right? Well, one time, I don't remember what was going on. But at one time I had to actually put up a baby gate to separate them. And I was getting ready to go somewhere and I didn't have the gate up. And I took Link with me everywhere. And I was getting ready. He wasn't on bed. He was down on the floor. I don't know why I didn't have him up on the bed. I said, Belle, go in there and watch Spike. Make sure he doesn't get in there and mess with Link. And I was just goofing around. Like, I really did not expect her to do that. But I said it to her. I was like, go watch your brother. Make sure he doesn't come in and mess. And so I went in the bathroom and I was brushing my teeth and hair and everything. I came out and I got my grab up Link. And I looked in the living room and Belle was standing right in front of Spike. And I was like, oh, I did it. I could not be. I'm like, that's probably a coincidence, but if it's not, that's scary. She did what I told her to stand right in front. Like he couldn't, and like going in front of him and wouldn't let him by her. I was like, oh my god, that's spooky. I don't remember what the excuse was, but I don't know. Like I said, maybe I don't have all the information. Maybe his wife was like, no way, I don't want to move. I don't know, but I don't know. So I guess he did. I thought only Jen McCabe and Katie McLaughlin testified to hearing I hit him, I hit him, I hit him. And I thought Katie McLaughlin said that there was a cop standing there that heard it too, but that none of the cops said they heard it on the stand. That Katie McLaughlin said she thought a cop had heard it, but then when the cops got on the stand, none of them said that they heard it. I did not remember this guy saying he heard it, but apparently he did. Only he said he only heard it. I don't even remember him saying that. I do remember him testifying. I remember that. But he was a good witness, though. I do remember him. He was, because like Lally didn't put him on first. He put on some of the cops and other folks for and I remember when he got on, I remember thinking what a better witness he was, like how more animated he was, and how he explained things better. And it was kind of like, oh, we can wake up now. We have someone interesting to listen to. So I'm kind of glad that he was and witnesses that Lally put on first. And his opening wasn't that bad. I mean, if you could at all, I mean, it was great. But last time had to mention everybody in the case. Like it felt like he said like 70 names in the opening, and it was like, and we know the case, right? And we still get names wrong. So why are you gonna say every name to everybody that's involved in the case in opening? No one's gonna remember those names. If you noticed when AP did his opening, anytime he mentioned a name, he slowed down and he repeated it. And when it was an Albert name, he would go Brian Albert or Chris Albert. Like he accentuated those names. Never once did he blame anybody and do the third person culprit thing that he wasn't allowed to do. But he did mention, like Bev said, well, let's just let him do it and see what happens, because we know that he knows he's not supposed to use the third person, whatever, in the opening, and he didn't. But like Hank didn't want him to mention any of that. None of it. How the back police were. There's no way. Peter Tragos did another podcast with his dad about this case and that motion, and it was so good. Peter's like, he was talking to in his firm when I used to be in law enforcement, and he was like, So, what would you think if a guy was found dead on the lawn and they didn't question the people that lived in the house? And the guy was like, "No way, that would never happen. No way." It's like, what would you think about them collecting evidence in red Solo cups? And they were like, "What? That didn't happen." And he's like, "Yeah." And he was like, they hadn't even followed the case, and Pete was telling them all about it, and they were just, they were amazed. They were like, "No way." So, like, all he has to do is just the bad investigation. So all he has to focus on. He doesn't even need to mention any of the conspiracy stuff in the opening at all. And after he got done, they thought that's it. He didn't mention any of the conspiracy. He didn't mention she was from nothing like that. Just bad police work. And I was like, yeah, woohoo, we won. That's, and the fact that he mentioned that Proctor got fired in the opening, genius, absolute genius. And I'm so glad they got all the disciplinary hearings and everything done before the trial started. Because if they hadn't, if that had still been hanging in limbo, he wouldn't have been able to use that in his opening. So that is just perfect. So perfect. And I'm just so happy he got that in there. That's just like icing on the cake. So I'm so happy. That was such a good opening. So if the jury can just look at that and pick apart, you don't have to know what happened to find her not guilty. You don't. All you have to know is that he wasn't hit by a car, and that the investigation was shoddy because they didn't investigate anything else that could have happened. They just confirmation bias. Like, they took what they had and made it look like he was hit by, or tried to make it look like he was hit by a car. Well, that's what I think, anyway. So I wonder how many of these people. Oh, send it to myself so I wouldn't lose it. Because it was on my phone. And when they oh, everything's gonna glitch. Yep, I just froze. Oh wait, I won't take that. Nope, it's not the right one. Aiden, this is the old one. So Aiden's still on here. Man, I hate this keyboard. I cannot see. Can't see squat unless I turn the lights out. Because I wanted a backlit keyboard. I didn't want one that I could see all the time. And day and at night. I just traded the day for the night. Phone down. It was just there. Go back. StreamYard. Yeah, let's everyone watch me technically stupid today. I guess we won't be looking at the list because oh, oh no, that's not cool. I have just made it huge again, like I did the other day. No, I hate my life right now, y'all. I hate it. Okay. Okay, let me see. Aiden, we know he's not going to call him. That's not the wolf from Arca. That's the other wolf, right? I don't know who that is. Allison McCabe. That's Allison McCabe. That's Jen's daughter, right? Andre. I can't read it. Too small. That's the crime lab. Andrew. Somebody. Andrew Renschler. Angela Malone. Malvone. Danny Chung. I don't know who these people are, but they're from Canton. There's Anthony Flamotti. Ashley Bell. Ashley. Somebody from the crime lab. Brian Albert. Brian Albert Jr. Brian Higgins. Brian Lofgren. Lofgren. Brian Wanless. Bridget Meehan. Caitlin Albert. Charles Ray. Helena Rafferty? She didn't testify in the last one. They won't let Turtle Boy be in the courtroom when she's there. I bet you money. Chris Van something. Christina Hanley. Christopher Gurin. Oh, my thumb's on the floor. Christopher Albert. Christopher Curran. Colleen Crawford. Colin Albert. Courtney Proctor. Kurt Roberts. David Whitley. Dan that wolf, that's one from ARCA. Derek Ellington, Dr. Marie Russell, Elizabeth Lafayette. Who is that one? Elizabeth Proctor. She didn't testify last time either. Erin O'Keefe, that's Paul's wife, so John's sister-in-law. Frances Walsh. What am I just not recognizing? Well, you weren't delayed, Judy. That's cool. You restarted your computer, didn't you? I wonder if it is your laptop. Well, his wife is going to be called. Well, I don't know if he has a habit of putting people on the list and not calling them, though. So I wonder. Well, I don't know. Eric Hanlon, Aaron Beatty, Aaron O'Keefe, Francis Walsh, Garrett Wing, Gary Fowler, Gregory Woodbury, Gretchen Voss. See, are they going to call Gretchen Voss? Seriously? He probably just wants to keep her out of the courtroom. Hannah Knowles, Heather, is that Mason or Maxon? I can't, it's too small. Arab Bear, Roberto Hernandez, Holly Price, Ian Whiffen, Irini Scortivello, James Crosby, Jason Becker, John DeMollis, Jennifer McCabe, Jessica Hyde, John O'Keefe Sr. What? Leave his dad out of this. Jeez. Jadson Welcher, Julie Albert, Julie Nagel, Justin Rice, Juvenile. That's one of the kids, Juvenile. Caitlin Boudreau, Karina Kolakitis, Maxon. Okay. Katie Camerano, Katie McLaughlin, keeper of record for Ring, Carrie Curran, Gary Roberts, Kevin Albert, Kevin O'Mello, Laura Sullivan. Oh God, Kyle. Why are they on the list? Lori Cahill, Leslie Pearlstein, Lieutenant Michael Link, Lewis Jutrus, Lieutenant Brian Tully, Lieutenant John Fanning, Lieutenant Paul Gallagher, Maggie Gaffney, Mark Lopalato, Margaret O'Keefe. Who is that his mom? Marietta Sullivan, Mary Souza, Matthew Armory, Matthew DeSogra, Matthew Erickson, Matthew Kelly, Matthew Polat, FBI, Matthew McCabe, Maureen Harnett, Mega Mariani, Michael Cameron, Michael Easter, Mike Trotta. Wait, I thought they said Easter couldn't testify. Michael Wagner, Mike Maroli, Mike Rushworth, Natalie Lowicki, Schneider, Nathan Reed, Nicole Bradford, Nicole Curran, Nicholas Colacane District. It's going to happen. Officer Kelly Deaver, Officer Nicole Barros, Patrick Haggerty, Paul Bukowski, Paul O'Keefe, Rebecca Balson, Rebecca Trayers. Some of these names I have no idea. Renee Stonebridge, MD. Richard Green. Another trial that we've been watching, that we've been waiting and covering. What trial is that? Gardner trial. Richard D. something. Robert Gilman, Ryan Nagel, Sarah Sergeant Brian Gallerani, Sergeant John Good, Sergeant Paul J.D. Sergeant Yuri Buchanan, Mount anybody that calls him the other name, Shannon Burgess, Cheryl Waugh, Sophie Eisen, Stephanie Devlin, Stephanie Mulaney, Steve Nelson, Steve Bernstein, keeper of records. For what? Keeper of records for what? Stoughton, Mass. Stephen Ridge, Sarah, Stephen Scanlon, Terry Kim, Tess Chart, Thomas Beatty, Thomas Kelcher, Thomas Martin, Timothy Nuttall, Tristan Morris, Trooper Connor Keefe, Trooper David DeSisco, Trooper Evan Brent, Trooper Jeffrey Koskowski, Trooper Joseph Paul. Oh, yay, we get Trooper Paul Physics again. Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark, Wendell Robbery, William Reed. From Tennessee, oh, Mike Rushworth, right there, Mike Rushworth. That is one of Proctor's buddies that got the text messages. So there's other people on organized messages. All right, StreamYard, take it down. Put Karen back up. Karen, my name's Debbie. Put Karen back up. Karen. No, no, not that. That's the wrong thing. You're killing me. Okay, so back to discussing what just happened in court. If they, this music's getting to me. If they, for instance, like with Jim McCabe, he was like, remember back when you testified in front of the grand jury or whatever, in that other hearing, you said such and such. And then he would show, will it refresh your memory if I show you the transcript? Why can't they do that from the previous trial? It's the same thing. It's the same sort of a thing, right? So why can't they have a transcript of the first trial and do it the same way? Just will it refresh your memory if you see a transcript of the previous trial? I don't see a difference. I'm going to be Yes, Belle, honey, I know. Mommy is working. And StreamYard is not cooperating. I don't want that up there. Ugh. Maybe if I turn off my camera. It's not going to let me turn off my camera. StreamYard, you had better behave before they get back from lunch. I'm going to be very angry. It's bad enough that you crashed through in the middle of AJ's opening. But now you're not cooperating with anything I asked you to do. Okay, I'm going to reload. I'm reloading StreamYard. If it'll let me reload it. I don't think she's going to make it to 30 at this rate. People are going to quit using her because we're tired of the way she treats us. I wasn't even doing anything and it crashed. Has it been a half an hour yet? Can you wait? Be patient. Oh, we have fam. Okay, guys, court's fixing to start. We gotta be quiet. We're in court now. Forgot the fact that we're eating, but we're not supposed to be eating. Gotta be quiet. Quiet. Oh, no. False alarm. I can't get a new laptop. I've got my recovery addict sticker on my laptop. I got my iPad right after I got my sticker, and I put my sticker on my laptop. I wish I had waited and I put it on my iPad case instead. I think I'm gonna start collecting stickers from the channels that I watch and put them on my laptop. Although I need a new laptop. I guess I need a new computer too.
Yes, Dave. Yes. Yes, please. Yeah.
That's Court TV. Court TV is frozen. That's not StreamYard.
Of Mr. O'Keefe. Do you
Yes,
recall is being punched in the face? Can that lead to a small laceration like you saw and a hematoma like you saw?
Objection.
I'm going to allow it.
Uh,
Can you answer that question?
I couldn't speak to how that injury occurred.
Is it consistent? Are those injuries, just those injuries, are those consistent with being punched in the face?
Those injuries could be sustained from a numerous ways.
And
Yes, it could be from that. It
That-
could be from others as well.
Okay, so that's what I'm asking you. It could be, in other words, it's consistent
Yes,
with
sir.
being punched in the face, correct? Correct. Thank you. I want to ask you about this statement that you indicate that you heard that now is 3 statements, 3 phrases, correct?
Yes, sir.
When you heard this statement, describe for me exactly where you were. What were you doing and who was around you?
I was knelt at the head of John O'Keefe with a bag valve mask. delivering ventilations. Firefighter Kelly was to the right, and firefighter Flamati was on the left side of Mr. O'Keefe, and the three of us together were working to perform CPR and ventilations.
And your job, and I hate to butcher it, but
Nope.
you'll correct me.
Yes, sir.
Your job was to do the airway, correct?
Yes, sir.
And I'm picturing a big balloon-like apparatus that you put over the patient's mouth. and
Exactly.
Squeeze it.
Yes,
That's as opposed to, it's an advancement on just mouth-to-mouth resuscitation, correct?
correct.
You were the airway person doing the squeezing of the bag.
Correct.
What was Tony Flamati, firefighter Flamati, doing?
He was starting that taken over by firefighter Kelly.
Okay, so firefighter Flamati, when you say starting CPR, describe what that means. What is the physical act of CPR?
So you put both hands together like this, one on top of the other. You put it right on top of the sternum, and you begin doing chest compressions 2 inches deep, allowing full recoil for 100 to 120 beats per minute, compressions a minute to sustain a cardiac rhythm. You're manually making the heart beat with each compression.
Which means that it is a rhythmic pumping motion, correct?
Yes, sir.
So if you see someone doing CPR, you're probably going to see their shoulders moving up and down and moving rhythmically, correct? Do you remember what firefighter Flamati was wearing? You had just come off of actually you were just coming onto a shift, so you didn't have all your foul weather gear officially, correct?
I had my puffy jacket.
Okay.
I had my Canton Fire jacket.
Got it. Firefighter Flamati, on the other hand, had a bright yellow jacket,
Correct.
sort of reflective and a safety jacket.
Yes, sir.
And he was kneeling to your left at the time doing, have I got that right?
Yep. Nope. Yep. You got that right.
Okay. He's kneeling to your left at the time doing chest compressions. That's when you indicate that Miss Reed walked over and made the statement.
Correct.
And Kelly was there as well?
Yes, sir.
Kneeling right beside all three of you as firefighter Flamati was giving the chest compressions, correct?
Yes, sir.
Okay. You indicated that the statement was in response to a question that you asked of my client. Do you know him?
Yes, sir.
Is that right?
Correct.
And she responded to you with the phrase that you've used. I hit him.
I hit him. I hit him. I hit him.
Right. So it's absolutely clear in your mind when that statement was made. You were knelt down over Mr. O'Keefe. Firefighter Flamati was doing the CPR, and Kelly was with the both of you when you posed that question.
Yes, sir.
It's a very detailed memory.
Yes, sir.
You indicated, Mr. Brennan, that sticks out in your mind. Is that right?
It does.
But that's not at all what you told Trooper Proctor on February 8th, just 10 days after this incident, is it?
I don't recall what I told Trooper Proctor.
I thought your memory got better with time.
I don't recall that meeting.
Okay.
I recall meeting with him, but I don't recall the extent of what was discussed.
You literally don't recall anything that was discussed in that meeting in that formal interview with the lead detective on this case.
We discussed the case, but I don't, in his words, I'm not sure what he put down.
What you said to Trooper Proctor on February 8th, 10 days after this, was you overheard Miss Reed say, I hit him one time to another female that she was talking to, correct?
Objection.
No, I'll allow it. Did you say that?
I have no memory of this, Your Honor.
Okay, next question.
Did you say that her statement was an answer to a question posed by the female or a discussion with the female?
Break that down for me, sir.
Sure. Did you tell Trooper Proctor on February 8th that what you heard was Karen Reed speaking to a female, not answering a question that you posed?
Again, I don't recall that specific question.
Did you tell Trooper Proctor on February 8th while you were rendering aid, and at the time you heard the statement, Miss Reed was actually praying over John, your words, praying over John? May I have just a moment, Your Honor?
Yes.
Did you say that you observed Karen Reed to have blood on her face from providing mouth-to-mouth breaths to Mr. O'Keefe prior to your arrival?
I remember Miss Reed having blood on her face, presumably from attempting CPR.
Do you remember telling Trooper Proctor on February 8th that you saw her with her face from CPR?
I do.
So you remember that portion of your conversation with Trooper Proctor, correct?
Yes, sir.
But the praying over John, praying over the victim, you don't remember.
I don't remember ever saying that,
And
ever.
And the statement, I hit him to another female, you also don't remember that.
No, sir.
Would it refresh your recollection if you were to look at a report
Yes, sir.
authored by Trooper Proctor? May I?
Yes.
He doesn't have to remember what Proctor wrote down. He needs to remember what he said to Proctor.
May I direct the witness's attention to the second page, Your Honor?
All right. Why don't you take a look at Jackson?
Jeez. Can you say coached witness?
May I approach, Your Honor?
Yes.
Facial expressions. Knock it off, dude.
Sir, did you have an opportunity to glance at the report that you were just shown?
Yes, sir.
Does that refresh your recollection about your conversation with Trooper Proctor that he put in a report?
It does not, sir.
So as you sit here, you have no memory of what you just read in this report from Trooper Proctor, the lead investigator on the case.
I have no recollection of ever saying that anybody prayed over anybody ever in this case.
You did see it in this report, though.
Right?
Sustained.
You've admitted under oath that your memory of the events at that time, from that time frame, January, February 2022, is faulty, correct?
No, sir.
In your April 2024, it's April 30th, 2024 testimony from last year. You were asked whether or not your memory was a little faulty, and your answer was absolutely, correct?
Could I have a page and number,
Where is
please?
that, Mr. Jackson?
Volume 8, page 151, lines 14 through 16. Lines 14 through 16. I'll just allow counsel to get that up.
If we could pose the entire question and give content to it, please.
Okay.
May I?
Yeah. So do you intend to show the whole question?
The whole question that I asked and his answer, yes.
All right. And I'll give you the opportunity. I'll redirect Mr. Brennan if it's not. Go ahead.
Isn't it true that in answer to the question, quote, so it's fair to say your memory is a little bit faulty as it pertains to that time frame? Your answer was absolutely. Correct?
From last year?
What you testified to last year about conversations that you had with Trooper Proctor around February 8th of 2022.
Yes, sir.
And you would agree, as you sit here, that your memory is still faulty about your conversation with him.
With
correct?
Trooper Proctor? Yes,
Yeah.
sir.
So you're not saying you didn't say that the statement was made to a woman, correct?
Objection.
Are you saying that?
No, ma'am.
Okay. Next question.
Thank you. And you're also not saying that you didn't say to Trooper Proctor that you saw Karen Reed praying over John O'Keefe.
Objection.
So I'd like you to ask that differently. Did you say that?
I have no recollection of saying that ever.
Next question.
My point is, if you have no recollection of it, you're not.
Still behave.
Objection.
You denying saying it?
Yes.
You do have a recollection that you,
I would have said. I didn't see it that day. It didn't happen. I don't remember ever saying prayed
you didn't
in
see
regard
it
to this case ever.
You didn't see it that day, and it never happened. That was your words just now, correct?
Break that down for me.
You didn't see it that day, and it never happened. That's what you're saying about the praying statement, correct?
Yes, sir.
And in that same exact statement, you also included the phrase, I hit him, correct?
No, sir.
In the statement that you made to Trooper Proctor?
The report that Trooper Proctor wrote?
Correct.
Again, I don't remember ever saying the words praying over him. I do distinctly remember I hit him, I hit him, I hit him.
Which doesn't appear in that report, does it?
Objection.
I'm going to sustain that, Mr. Jackson. You directed him only to page 2.
Understood, Your Honor. I'd like to show you a short portion of a video, the same video that you were asked to look at on direct examination. And Your Honor, I pray to the court, I can certainly mark it as a defense exhibit or for
So is this
identification.
going to be an exhibit by agreement?
It is.
It
Okay,
is.
So we now that, Madam Court Reporter, thank you.
I swear y'all send me texts just to get me to laugh on stream, don't you? You do it on
Thank you, Your Honor. With the court's permission, may I play a portion of that video for the jurors, publish it?
Okay. Which portion so people know?
I'm going to start it at about, I want to say 6:55. Mr. Walt could cue that up. Before you play it, can we have it on that screen as well, or is it only playing to this screen?
I don't know. When Ms. Gilman did it, it was both. Great.
There we go. All right. Before we play it, can I ask you a quick question about this?
Sure.
It appears that this is paused. Do you recognize this as being the same video that you were shown this morning by Mr. Brennan?
I do.
All right. Describe the scene.
So that is 34 Fairview Road. The lights in the background, I believe it is either right as we pulled up or right as we're pulling up.
Okay. Same dash cam video.
Yes, sir.
Can we scroll this to the 6:55 runtime spot, please? Pause it. Okay. Do you see the individual on the left? Far left.
Yeah, the jacket?
Correct.
Yes, sir.
Who's that?
I believe that's firefighter Flamati.
You previously indicated that when you heard Ms. Reed make this statement, that firefighter Flamati was on his knees providing CPR at the same time you were knelt down providing the airway.
This isn't when it was
That's
stated.
not my question. Is that what you said?
Can you repeat the question, please?
Sure. You indicated earlier when you heard this statement by my client, you were very detailed. Firefighter Flamati was knelt down providing chest compressions at the same time you were knelt down providing airway support for Mr. O'Keefe, correct?
I had also said that at some point,
That's a yes or no
Flamati
question.
Objection.
So I'm going to let the witness answer the question.
had transferred CPR to firefighter Kelly. Firefighter Kelly did take over compressions at one point.
Okay. That's not my question.
Answer
The
the
question's an easy one. Did you say that when Miss Reed walked over to you and you had this dialogue with her, she made that statement that firefighter Flamati was on his knees providing chest compressions at the same time you were knelt down providing airway support?
Yes, sir.
Okay. Firefighter Flamati, your testimony appears to be standing up right there, correct?
Yes, sir.
Let's play the video forward for just a second. Stop it. What did you see firefighter Flamati do just now?
I believe he just knelt down.
Okay. So at this point, he's kneeling for the first time, correct?
Yes, sir.
And he's about to provide chest compressions as your memory serves, correct?
Yes, sir.
All right, let's go ahead and play it forward. Pause. Did you see my client in that photo? I mean, I'm sorry, in that clip?
No, sir.
You didn't see her?
Oh, no, I did see her. Yeah.
Yeah.
I don't see her on right now.
Right. She just walked off frame, correct?
Yes, sir.
Let's go ahead and play it forward. Stop it. You see my client walk back into the frame.
Yes, sir.
At this point, you were watching firefighter Flamati. He appears to be now providing CPR, correct?
Yes, yes, sir.
Okay. And my client is nowhere near you, correct? At least for this clip.
No, sir.
Okay.
Correct.
And the clip that I just played before, the few seconds that I played before, nowhere near you, correct?
Correct.
Is that right?
Yes, sir.
Let's go ahead and play it forward. Pause it, please. What do you see happening on the screen from screen right to screen left at this juncture?
We're bringing in the stretcher.
Okay, go ahead and play it. Pause it. Do you see where my client is right now?
Can you back it up 2 seconds? I'm sorry, I lost
With the
view.
court's permission, I need to ask the court's
Yes.
permission. Thank you. Okay, let's go ahead and play it. Pause. Did you see my client?
Yes, sir.
Where is she in the frame?
Behind that other individual.
Behind the SUV?
I believe she's in front of the SUV and behind the other individual.
Okay. I meant the SUV, that's the white SUV that's in
Yes, sir.
the far distance.
Yes.
That's the back of the SUV. She's behind it, right?
Correct. Yes.
Okay. Not near you.
No.
Okay. Let's go ahead and play it. Go ahead and pause it. Do you see what firefighter Flamati is still doing throughout this entire clip?
Chest compressions?
Okay, let's go ahead and play it. Pause. What's happening now?
Where Mr. O'Keefe's on the scoop stretcher and he's being transferred to the ambulance stretcher.
So that's the entire time Mr. Flamati, firefighter Flamati, was giving chest compressions. It's captured right here on this video, correct?
Yes, sir.
Okay. And now Mr. O'Keefe is up on the stretcher and you are no longer knelt down,
No, sir.
and firefighter Flamati is no longer knelt down,
No, sir.
and you're now following the stretcher with, it looks like 2 or 3 other EMTs, correct?
I am not in that frame, sir.
Okay, so you've walked away.
Yes, sir.
All right. Let's go ahead and play it forward. Pause it. You see where my client is?
Yes, sir.
Go ahead and play it. Do you see firefighter Flamati or firefighter Kelly continuing to give chest compressions?
Yes, sir.
Which one is that? Do you know?
Believe it's firefighter Flamati.
Flamati?
Believe so.
Okay, so he's still doing all the chest compressions from start to finish.
Yes, sir.
Okay.
Why isn't he still there making?
What's happening right now?
Now you're transferring to ambulance 1.
And where's my client?
Right front and center.
May I have just a moment, Your Honor?
Yes.
If I may have just a second. With regard, just a couple of more questions with the court's permission.
Okay.
I'm going to change gears with regard to what you talked about on direct examination, the hypothermic conditions. You're not a medical doctor, correct?
No, sir.
You don't diagnose patients?
Sir.
You're not diagnosing that John O'Keefe suffered from hypothermia that night?
No, sir.
Thank you. That's all I have.
Any follow-up?
Please. Firefighter Nuttall, the video the defense just showed you, did you notice any differences between that video and when I showed it to you, and that it doesn't have the time on it?
Yes, those were two different time frames on that video.
And when we spoke about when the defendant said to you, I hit him, that wasn't shown to you in that video just now, was it?
No, it was not.
So if we go back, will you be able to explain where you came from and firefighter Flamati came from and when you first went over to John O'Keefe?
Sure.
With the court's permission, Ms. Gilman, if you could start that video. I think it is 6:11, please. Now stop it there. Do you see that this exhibit has timestamp on the top?
Yes, sir.
Okay. Please continue.
At least we don't have to watch them driving street after street after street like we did in the last trial.
Could you stop, please? Do you see the red lights on the left?
Yes, sir.
Is that when you believe that you first arrived?
Yes, sir.
And that note says 6:11:05. Could you continue, please, Ms. Gilman? Please watch to the left. Stop, please. Is that when you first arrive and walk over to help John O'Keefe?
Yes, sir. That's me.
I'll note that the timestamp is 6:11:21. Okay, continue, please. Stop, please. Did you see firefighter Flamati come after you?
Yes, sir.
Was any of this shown to you during those questions?
No, sir.
No. Continue, please. Stop, please. Do you see the defendant in that screen?
Yes, sir.
Do you see her moving from right to left towards you?
Sustained as to the form.
Okay. What direction do you see her running in that screen from right to left?
She's running towards where the three of us are grouped.
Okay. Please continue. Stop, please. Is it at that time the defendant said to you that she hit him?
Yes, sir.
And you remember that?
Do.
Okay. I'm done with the tape. Thank you very much. Now, you were asked questions about your memory.
Yes, sir.
Okay. When you were asked the questions about Trooper Proctor, when you were saying that you didn't remember, were you referring to the conversation with Trooper Proctor Or were you suggesting you didn't remember what happened that morning?
I don't remember the interview with Trooper Proctor. I remember it happened. I don't remember the substance of what was discussed entirely. I remember we discussed that morning, but
Do you know if that conversation was recorded or just a conversation between you and the trooper?
I do not know if it was recorded.
You asked questions. I want to ask you about questions on Mr. O'Keefe. And you mentioned that there was some type of blood clotting on the back of his head.
Yes, sir.
You noticed there were abrasions on his right arm.
Yes, sir.
You noticed there was a hematoma on the right side of his head.
Yes, sir.
Did you see any bruising on his right knee?
Don't recall, sir.
Did it stand out to you that all of his injuries, all of them that you saw, other than the cut on the back of the head, that they were all on his right side?
Yes, sir.
Did you notice any hematomas on his left side?
I did not.
Did you notice any scratches or abrasions on his left side?
I did not.
Did you notice any marks that would be consistent with an altercation on the left side of his body?
I did not.
You were asked about the cause, and you said that you don't know the cause. You weren't there, were you?
No, sir.
You asked if it was consistent with being punched, and you said it could be.
Yes, sir.
Could it be consistent with being clipped by a car?
Sustained as to the form.
You were asked questions about clothing,
Yes, sir.
and you had at one point said you thought that Mr. O'Keefe was wearing a winter jacket. Do you have any memory that when you first got there, or when you first got there, do you have any memory whether there were any towels wrapped around Mr. O'Keefe's head?
I remember there was a white cloth of some sort on the scene.
Okay. And when you were asked about your memory regarding the clothing, was the clothing of what was utmost importance to you at that time?
No, sir.
And why is that?
I was, again, focused on Mr. O'Keefe's airway and ventilation.
Okay. And when you were asked about the clothing, remember if you added anything else about your certainty or uncertainty about clothing when you previously gave a statement or testimony?
I believe when I testified last year, I did note I had no part in removing any articles of clothing or anything like that. That was not my job in the back of the truck.
Do you remember any recognition of the fact whether you were certain or not about clothing?
Repeat the question, sir. I'm sorry.
Well, is there anything that would refresh your memory about what you had said about clothing? You had some difficulty about clothing. Do you remember what you had previously said?
I remember there was some difficulty of getting the individual's fingers through clothing just because they were so cold. They were difficult to manipulate. Just they really was not conducive to getting clothing off easily. You
met with me 3 times?
Yes, sir.
I had not met you before any of your prior testimonies, had I?
No, sir.
Do you remember meeting with me and discussing this case with me?
I do.
Do you remember me asking you to tell me what you remember?
I do.
Do you remember what I told you about testimony when you come into court?
Yes, sir.
What would I tell you?
I remember we discussed that just tell the truth.
Did I tell you that it doesn't matter? There is no side. Doesn't matter if it helps or hurts, that you just tell the truth?
Sustained.
Did I ever suggest to you that you should stick to a story?
No, sir.
Did I ever suggest to you you should offer your testimony in any certain way?
No, sir.
When I talked to you, did I ever ask you to say anything about your testimony to this jury?
No, sir.
Other than what?
Speak to the jury.
Did I need to tell you to tell the truth?
No, sir.
And in telling the truth, did the defendant say to you,
I'll allow it.
Yes, sir. 3 times.
And in fact, do you remember, in addition to her saying, I hit him, when you asked her the question, kneeling down over John O'Keefe's body, do you remember if you ever talked about other times that she said it, not to you?
I do not.
Okay.
The answer is I do not. Next question.
Okay. Do you remember testifying previously in this case?
Yes, sir.
Do you remember at all discussing whether or not, after she left you, whether or not the defendant was still talking and speaking?
I'm sorry, sir. Repeat the question.
Do you remember after the defendant left you and made that statement to you? Do you remember talking? Did you hear her speak to other people after you?
I heard her having conversations in the background, but that was not my focus at that time.
Okay. And during those conversations in the background, did you hear her talk about that same issue again?
I believe she said it several times, but the 3 times she said it to me were what stuck out to me.
Okay. And when she said it to other people, it wasn't directly to you?
No, sir.
So watch the form of the question, Mr. Bowman.
And when she said it to-
Stating the objection.
When she said it to other people, do you know who she said it to?
I do not.
I'll allow it. So the answer is I do not.
I'm sorry.
Do you remember when she said it other times who she said it to?
I'm going to see counsel at sidebar for this.
So, did she run around to different people and say, I hit him, I hit him, I hit him 3 times to everybody that she said it to? I hit him, I hit him, I hit him. I hit him, I hit him, I hit him. To everybody that she said that to? She said it 3 times, every time she said it? Sure, she did. Because 3 is the magic number, right? Good Lord. And Hank, it is not a hematoba. Darn it, I forgot I was supposed to call during lunch and pay this bill. I am so mad. I get this letter, final notice, past due balance of $34.84. Across the top of the bill, it says total patient balance due $40. Huh? Total past due $34.84. So where do they get 40? Number 1. Number 2, I tried to pay the whole thing, and for some reason, it didn't pay the whole thing. I owed 100 and something, and it only paid 60 something. So when I got to the doctor's office, I said, is my whole bill paid? And she said, yeah, you're good. It's all paid off. And then I get this in the mail yesterday. I was supposed to call him today and forgot. Call him tomorrow.
Sir, after the defendant came over to you and spoke and then left, do you remember hearing her make further statements?
Yes, sir.
And do you remember her making further statements similar
I do.
to the statement to you?
Yes, sir.
Could you share with the jury what you remember her saying, not to you, but after she left you?
I remember hearing I hit him several other times. Again, not directed to me, just kind of off in the background. I'd like to reiterate, we were really focused on the patient at that point. We were trying to provide care.
Thank you, sir.
And he's saying repeat the question 5 times is what he's doing. They always do that 5 times.
So now, after Mr. Brennan asks you a few questions, now you remember her saying, I hit him a bunch more times.
No
Correct?
comments.
I remember hearing it in the background
Don't
several
comment.
other times.
Really?
Sir,
Never mentioned that on direct examination, did you?
I don't remember being asked about it, sir. I remember saying what was asked to me.
You were asked, did you ever hear the defendant, Ms. Reed, say anything about I hit him? And your answer was, she said to me, in answer to my question, I hit him, I hit him, I hit him 3 times, and that's it.
To me.
You didn't clarify that, oh my gosh, she's running around like a chicken with her head cut off, screaming I hit him to everybody else under the sun.
It was, again, it was behind me in the
Yeah.
background
Right?
as I was providing patient care. Again, that was not my focus.
Okay, so you didn't really hear her say anything in the background because you weren't focused on that, right?
I remember hearing generalized commotion in the background, but again, that was not our focus.
So generalized commotion is very different than hearing her say, I hit him to other people, correct? You'd agree with that.
Yes, sir.
So what you actually heard was the chaos and the commotion of a chaotic scene, correct? In the background,
In the background.
as you focused on your patient care, correct?
Yes, sir.
Okay, not specific words coming out of my client's mouth, correct?
To the question that I posed, do you know him?
You're right. We're off that question.
Okay.
That question, I got it.
Yes, sir.
Triple I hitters.
Correct.
But with regard to what Mr. Brennan just asked you, the generalized commotion, to use your phrase,
Mhm.
in the background, you didn't hear any specific words coming out of my client's mouth, did you?
I heard I hit him. But again, it was in the background and it was not my focus.
Well, why didn't you say that on direct? That's kind of an important point. That's why you're here.
Again, if it was neglected on my part, it was not intentional.
Not intentional to neglect that part for the jurors on direct examination.
No, sir.
Certainly not intentional to neglect that part of your testimony on cross-examination.
No, sir.
But you decided to bring it up on on recross examination when Mr. Brennan is asking you questions again, correct?
It was asked of me. Yes,
And
sir.
it was after, of course, that your new statement that you've never testified to before, ever, is
All right.
this generalized commotion included a bunch of I hit hims in the background, correct?
Sir.
And that comes after you saw the video that clearly shows that when you describe having heard this statement, my client was nowhere around you, correct?
That segment of the video that you showed me,
Yes.
that was not the time frame in which she said that to me.
Well, that was the time frame when Flamati was giving CPR, correct?
He was doing CPR down prior to that as well.
Really?
Yes, sir.
Well, you just testified that you saw him standing up in a big yellow jacket and then kneel down and start giving CPR. We just watched that video. Correct?
But again, the clip of the video that you showed me,
Right?
that was not the segment in which she said that to me.
Well, that's what you're saying now, but what I'm asking is, you described a very distinctive scene, a very, very specific scene.
Yes, sir. I remember it vividly.
She said, the I hit him phrase, when Flamati was down giving CPR, and you were kneeling down giving airway support, and he was doing rhythmic CPR chest compression.
Yes, sir. That's what happened.
And then I showed you that very scene, didn't I?
Yes, you showed me that clip prior to that.
I showed you the very scene that you described where Flamati gets down and starts chest compressions and never stops until the gurney is taken off the frame of the camera to the end. Isn't that what I showed you?
That is,
Sure. I don't know if I can do it again. I showed you the scene where firefighter Flamati gets down on his knees, begins chest compressions, and never stops until that gurney is taken off camera, off frame, into the ambulance. That's the clip I showed you, correct?
that's the clip you showed me.
And that's exactly when you described your vivid memory from 3.5 years ago. That's exactly the scene that you described when my client supposedly said, I hit him to you, correct?
Again, the clip that you showed me, that was not when it was said. That segment that you showed, that was not when it was said. It was said prior to that, when the
Yeah.
three of us were together.
So Flamati was not giving chest compressions then.
He was. The CPR was a continuous effort throughout the resuscitation.
But we saw him start it. Firefighter Nuttall, we saw him start it. We saw him walk into the frame, kneel down, and begin the chest compressions, didn't we?
We did.
And at no point at that time or after did my client even approach you, did she, in that clip?
She did.
What?
Objection.
Sure.
Bald face lying. We saw it with our own eyes.
Do you need to see the that clip again?
Yes, please.
We're not going to show the video again.
Ugh.
We've seen 2 videos. Which one is marked?
Which one's a mock? Which one's a mock?
The
The
Commonwealth.
one with the timestamp at
Right.
the top?
It's the exact same video. One has a timestamp, one doesn't. Just to be
We
clear,
need to play it again, Bab.
you described a
lying.
very detailed scene in which firefighter Flamati got down on the ground on his knees and began CPR.
Yes, sir.
We saw a clip that it played fully through.
Mhm.
Starts and stops, but it played fully through, correct?
Yes, sir.
That was true and accurate video of what happened that day,
Yes, sir.
that morning, correct?
Correct.
And from the time firefighter Flamati began his CPR, he never stopped. Went all the way through until the burn was taken off the camera, correct?
Correct.
You also described very clearly before you saw the video that the time when my client walked over and you had this dialogue and you heard this statement, it was during the time that firefighter Flamati was given CPR, correct? You described it.
Yes, sir.
But when we actually see firefighter Flamati giving the CPR, as per your description, at no time did my client walk over and have a conversation with you, did she? In
She-
that video?
She did in the video.
In the portion that Mr. Brennan played you, was firefighter Flamati giving CPR at that point?
As I said previously
Was
as well.
he or was he not? Yes or no?
Objection.
I'm going to let the witness answer the question.
Firefighters Kelly and Flamati were trading off CPR. Tony started doing CPR, and it was passed off at one point to firefighter Kelly. Firefighter Kelly at that time was a BLS EMT. Firefighter Flamati was a paramedic. They're going to bring CPR because at that time his is Tony's. But they did switch off. That is a routine cardiac arrest. We switch off compressions.
But the video that Mr. Brennan showed you was earlier in time, a few seconds or a minute or two earlier.
Yes, sir.
You'd agree with that, correct?
I would.
And firefighter Flamati had not begun CPR, had he?
I don't believe so.
That's right, he hadn't. But that's the time that my client walked over in your general area, correct?
Correct.
Before CPR was started, correct?
CPR was started immediately, sir.
Can we wrap this up?
I don't know if we can, Judge.
Give you a couple more minutes.
Bev,
Do you understand the confusion?
he's trying to
Objection.
straighten out an
Sustained.
inconsistency in his testimony.
All right, a couple of more questions on this.
Can't wrap it up.
The video that Mr. Brennan showed you,
Yes, sir.
and you pointed to and said, oh, that's the time when she walked over and said the statement.
Yes, sir.
Remember that?
I do.
Firefighter Flamati was not even kneeling down giving CPR, was he at that point?
No,
The answer is yes or no?
no.
Okay, he was not. Later, as the video continues to run, at some point, we see firefighter Flamati enter the screen, kneel down in that bright, reflective yellow jacket, and begin CPR, correct?
Yes, sir.
You had previously said that when you heard the statement and she walked over to you, it was when firefighter Flamati was giving CPR, correct?
Yes, sir.
And at no point, you'll agree with me, we just played the video, at no point after he started giving CPR did my client come anywhere near. Isn't that what the video showed?
That was the segment that you showed me.
You indicated on on redirect, that Mr. O'Keefe did not have any injuries to the left side of his body.
Not that I recall.
Isn't it true that in addition to the egg on the right side of his head, he also had a black eye on the left side?
I remember that the swelling had started to, it's referred to kind of as raccoon eyes. It's a bruising of both eyes.
Do you remember
battle
saying-
signs?
Do you remember saying, in answer to the question, did it look like in addition to the egg on the right side of his head in the front, did he also have a black eye on the left side? Your answer is, if memory serves correct, yes.
Yes, sir.
So it's not true that he didn't have any injuries on the left side of his body or face, correct?
That swelling kind of migrates over time to both sides. That is a common occurrence for both eyes to be swollen.
Did he have an injury to the left side of his face?
He did not.
Did he have a black left eye?
Yes, he did.
Would you consider a black eye an injury?
Yes, sir.
Let me ask you the question again then. Did he have an injury to the left side of his face?
Yes, sir.
Thank you. One last question. You indicated that it was a chaotic scene outside on that front yard.
Yes, sir.
Fire engines, ambulances, patrol vehicles, engines running, diesel engines, flashing lights, people screaming, people talking over the howling wind, correct?
Yes, sir.
Did you ever see the homeowner come out the front door?
Don't recall.
You don't recall, or you didn't?
I have no idea who the homeowner is.
And you never saw anybody come out of the front of the house?
No, sir.
That's all I have.
One issue. Briefly.
I want to see Councilor Tybar.
Why? Why, Bev? Why? Don't start to crap now, Bev. First witness, and you're starting chiz. What the hell? The video is important. He just said, she said it when they were doing a certain thing, and it doesn't match up with the video. So he had to backpedal. And AJ was willing to backpedal it and show the video again. So don't be that way. There's an inconsistency in his testimony. They need to clear it up. If they have to show the video again, they have to show the video again. I hate this woman so much. So much. Well, not her personally, but you guys know what I mean.
Sir, in Mr. Jackson's questions, he asked if you had ever said that you heard the defendant say, "I hit him," separate from when she approached you. Do you remember previously testifying that you heard her saying, "I hit him in the background," separately from you?
Yes, sir.
You remember testifying that before under oath
Yes, sir.
in court?
I do.
Anything, Mr. Jackson?
Yeah, just a second, Rob.
sorry.
I wish I was Eliza Little right now. Oh, did I send it?
Yes.
Just a quick question, firefighter Nuttall. When you were asked to recite your memory of that day on February 8th, 2022, just 10 days after this incident, did you ever say that you heard in the background, "I hit him" over and over again?
I don't recall.
All right.
When you testified at the grand jury, last question, when you testified at the grand jury, did you ever say that?
I don't recall.
But again, your memory is better now than it was then.
Yes, sir.
All right. Firefighter Nuttall, you are all set.
Thank you, ma'am.
All right, your next witness, Mr. Brennan.
Thank you. The Commonwealth calls Kerry Roberts.
Oh, here we go.
Kristen, can I have it?
In the stand, I did have an exhibit I would like to introduce and
Okay.
play for the jury.
Okay.
And this is clip 2.
No objection from the defense? And you're marking this as an exhibit?
Yes, Your Honor.
Okay. Do you have something for the court reporter to mark?
We can put it on a zip drive. We can discuss collecting all the clips and putting them on the same zip drive, or we can use different zip drives, whatever the court's preference is.
So we need something. So we
Okay.
need something physical. You can play it and then we'll mark it.
Ms. Gilman, do you have a separate clip?
Jim, is that right?
Thank you. I can have this marked, Your Honor.
Thank you. All right, Ms. Roberts, please. Okay, thank you.
We'd like to play this first and then call Ms.
Oh,
Roberts.
okay, I'm sorry.
Thank you, Your Honor.
I remember it, but I questioned do I remember it because it's been relived so much. I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually remember that. But I've seen the video so many times that you then question, did I remember on my own or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that. So the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Thank you. I'd now call Kerry Roberts.
Yeah, I wasn't expecting her either.
During the case down here, to the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Oh, it's why I thought it was like.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your
Good afternoon,
Honor.
Ms. Roberts.
Good afternoon, ma'am.
Good afternoon.
Could you please introduce yourself to this jury?
Hi, my name is Carrie Roberts.
Ms. Roberts, where do you live?
I live in Canton, Massachusetts.
How long have you lived in the area for?
I was raised in the Boston area, North Shore, South Shore. I went to high school in Braintree and I moved to Canton about 12 years ago.
Do you live alone?
No, I live with my husband and 2 children.
How old are your children presently, this day?
My son is 13, my daughter's 15.
Do you work?
Yes, I do.
Without identifying specifically where, can you share with us a little bit about what you do?
I'm an executive assistant, and I've been with my company for 18 years.
Ma'am, if you could just move the microphone just a tiny bit closer. Thank you very much. You have 2 children, you're
Yes.
married,
Yes,
and you live in the area.
yes.
I want you to tell us whether you know a person by the name of John O'Keefe.
Yes, I do.
Would you be willing to share with us when you first met Mr. O'Keefe?
Well, I went to high school with John in Braintree. He played soccer, I played soccer, so we probably hung out in middle school, but we went to 2 different middle schools. And then I hung out with him more in high school. He was a year older than me. His sister was 2 years older than him in school, and his brother was younger. So at some point, I was in high school with each of his siblings.
Did you at some point become friendly with John O'Keefe?
Yes.
Could you tell us about that?
When his sister Kristen passed away, and then her husband Steve passed away, they lived in my neighborhood. John took over for the children and moved into my neighborhood as well.
When John took in the children, did you offer any assistance or any help to him?
Yes, before John was even going to take over, he was going to potentially move in with his brother-in-law and the children to help out. And then when his brother-in-law passed away unexpectedly, John took over, and I jumped in because I was a friend from high school that he knew, and he had all kinds of people helping, but he sort of said, I'm going to lean on you for right now because I know you best. And I knew his parents and his siblings. And so I introduced him to my husband, and we jumped in. It was, preschool drop-offs, preschool pickups for my son and his son. And just from then until the time of his death, we were just friends, very close friends. And we hung out all the time. The children hung out all the time. And he was the emergency contact list at my children's school to call if something had happened.
Were you close friends before he took over the care of the children?
No, I wasn't very close friends with him then.
Were you close with his family before he took over care of the children?
No.
Did your friendship with him develop after he took care of the children?
Yes.
You mentioned you have a son.
Yes, I do.
And is your son the same age as John's nephew?
Yes.
Was there any common interests or activities that engaged your son with John's nephew?
Well, they went to in-home daycare together. They went to preschool together. They went to pre-K together. And they went to elementary school. They played baseball together since they were T-ball. My son plays hockey. Patrick tried hockey. He didn't like that. So we spent a lot of time at the baseball fields together.
As you spent a lot of time together and had mutual care of children, did your relationship with him grow closer?
Yes.
And can you share a little bit with the jury how close you became?
Well, John was a bachelor and he didn't have any children of his own. So when he took over for the children, he sort of, leaned on us to kind of guide him and, all the things to do if someone has a headache and, if there's an ear infection or, he had his mom and dad also helping as well, but I was right up the street. So if I would go to BJ's, I would call and say, can I grab you anything? If I would go to Walmart, any of the places I would go, I would call and say, do you need anything? Can I help you? Can I grab something for you? And he did the same. We just sort of all chipped in, helped.
As your friendship grew, could you tell us a little bit about your relationship with John?
John and I were very close. We spoke on the phone and hung out. He became very close with my husband as well because he was right down the street. But we just had a friendship, a very close friendship.
Tell us about the day-to-day activities and how you would try to assist John with the children.
Oh my God.
Well, John moved across town. I don't remember when. I forget how many. Patrick, I think, was in 5th grade or 4th grade. And I would take him home with me on Wednesdays because John would be working. So It was more of a, if he was at my house and my daughter needed a ride the other side of town, he would take her with him. We were just very close friends. We did a lot together. We would do baseball tournaments together. We would have drinks together. We would, all the things friends do.
Hey, can
As
we
you grew
talk?
closer to John and helped with the children, did you become closer with his family?
Yes.
And who specifically did you become closer with?
Mrs. O'Keefe and Mr. O'Keefe, his parents, and Paul, I would see from time to time, but not a lot. He doesn't live in Canton. But Mr. and Mrs. O'Keefe would be there all the time to help as well. And Mr. O'Keefe would take my son and Patrick, the nephew, out to Dunkin' Donuts all the time.
Can you tell us a little more about the collective effort of other people, including his family, helping John raise these children?
There was a lot of us that jumped in to help. It was not just me. There was a lot of Kaylee's friends' parents that jumped in and helped out for Kaylee, his niece, and Patrick. There was a lot of us that helped out with Patrick. All of the community all came together to help him because there was this guy that just lost his sister and brother-in-law, and he stepped in to take care of his two kids, and he didn't really know what he was doing at first, but he got the hang of it pretty quickly.
You have a son that shared a lot of interests with his nephew.
Yes.
He also had a niece.
Yes.
Did you spend more time helping with his nephew or with his niece?
With his nephew.
Were there other people in the community you knew of who spent more time helping with his niece?
Yes.
And who was that?
Jen McCabe.
Did you know Jen McCabe?
I had met her once. John got a discount at Reebok, so he would take the kids, he would take anyone with kids up with him to get shoes, like sneakers for back to school or whatever. So one day he did take Jen and I up to Reebok, but other than that, I never talked to her on the phone. I never saw her out. Her children are older than mine, so we never really crossed paths.
As it relates to the night of January 29, 2022, how much earlier was it that John took you out with the children and Miss McCabe out with her children to get sneakers? How many years before that?
Years, like 6 or 7 maybe.
And from that time you met Jen McCabe in the years past, did you ever spend time with her again before January 29th, 2022?
No, I did not. I didn't know her.
Were you friends with her?
I was not.
Did you speak on the phone with her?
No, I did not.
So other than that one meeting, you were strangers?
Yep, that was the only time. I knew her. I knew of her. She has 4 girls, but I didn't know her.
At some point, as you were part of John's life, did you learn that he was dating a person by the name of Karen Reed?
Yes, I did.
And do you see that person here in the courtroom today?
Yes, I do.
Could you point her out and describe an article of clothing that she's wearing?
She has a black suit jacket seated at the front table.
When did you first become familiar or know about Miss Reed?
July, I think it was, of 2020. John, we were having people over, and so I invited him, and he said, I'm going to bring Karen over. And I was like, I don't know who that is, but okay. He assumed I knew because he had been dating her for a little bit, but it was COVID, so we didn't see him very often during that time. So Karen came over that night.
This is early 2020?
I think it was summer, so I think it was around June or July.
Briefly, just tell us a little bit about where and the circumstances of meeting John and Karen for the first time.
They came over to my house and we hung out on the back porch, had some drinks. There was music, kids were around, just a nice, normal summer night. We had other people over as well.
Over the next coming months, did you become more familiar with the defendant?
Yes.
Did you see her more often?
Yes.
And could you generally describe for the jury how you learned more of her and saw her more often?
She would take care of the kids a lot, mainly, well, not mainly Patrick, but not mainly Kaylee either. She helped out a lot with the kids. So if we were at baseball, she would come to all the baseball games, or she would drop off or pick up my son or Patrick if they were going to the golf course or the driving range.
Would you see her during events with your son and John's nephew?
Yes. We did baseball tournaments. And
so when you go to baseball tournaments, would that be away, an overnight type trip?
One of them was down the Cape.
How often would you spend time with John and the defendant?
Not that often together, but John would stop by himself. My husband would go out more with John, but I didn't spend much time with the two, not a lot of time outside of the baseball field.
Did you become friends with the defendant?
We were friendly.
Did you ever spend time alone to go out or socialize?
I did not.
Would you see her when you would pick up or drop off kids, or she would pick up or drop off kids?
Yes.
Did you ever speak to her on the phone?
Yes.
In relation to what?
Corresponding with the kids, pick up, drop off, mainly Ryan and Patrick, not about Kaylee.
Did you ever spend any important dates or times or holidays with John and Miss Reed?
No.
I want you to take us ahead to January 28th, 2022.
Okay.
On January 28th, 2022, do you remember that day?
Yes.
Generally, what do you remember about the day of January 28th, 2022?
There was a blizzard coming, and it was my daughter's friend's birthday. So we were going to be going out celebrating that night, but we did it on the early side because there was a blizzard coming.
What was your plan for that evening?
We went bowling. We got dinner, then we went bowling, and then I came home because I wanted to be in before the snow started.
Had you communicated in any way with John that day?
Yes, he texted me. My son had an issue at school. Patrick had been dismissed, I think, for a doctor's appointment. So he did text me to see how my son was doing.
Did you simply text, or did you get a chance to speak to him that day?
I believe we just texted.
Did you go out that night after bowling?
No, I did not.
Was your husband home?
Yes,
Did he go out that night?
he did. He went out with John.
And do you know where he was planning on going?
They went to McCarthy's, a bar in Canton Center.
Had you been to McCarthy's before?
Yes.
Can you just briefly describe what McCarthy's is?
It's a restaurant bar. There's a large bar in the middle, the seating on the left and the right. It's right in the center of town.
Do you remember about what time your husband went out?
I do not remember exactly. I don't know if I got home and then he went out, or if he was already gone when I got home. I don't remember, but it was he went out around the same time that I arrived home, which was on the earlier side.
How many times had you been to John's home, would you say, over the past couple of years before this night?
Oh, many.
Many times?
Many times.
Were you familiar with the house and the driveway?
Yes.
May I approach you on?
Yes.
Should I return to the podium and ask the question?
You
John?
can ask something there.
Thank you. Ma'am, I'd ask you to take a look at that photo in front of you. Do you recognize what is in that photo?
That is John's house.
Is that a fair and accurate depiction of how his house looks?
Yes, it is.
I'd like to move this to evidence, please.
Okay, any objection?
No objection. May I publish to the jury, Your Honor?
Yes.
Thank you. Thank you. Can take it down. I've shown you a second photo. Do you recognize what's in that photo?
Yes, that's John's driveway.
Is that a fair and accurate depiction of how John's driveway appears?
Yes, it is.
I'd move that into evidence. No objection.
Okay.
Exhibit 7 so marked.
May I publish?
Yes.
Could. Thank you. I'm showing you a third photo. Do you recognize what's in that photo?
Yes.
And could you share with the jury what's in that photo?
It's the side of John's house looking up from the driveway.
Is there anything you notice on the side of the house?
The lights or the Ring camera.
Are you guessing or do you know that's a
No,
ring camera?
I know there's one there
And how do you know that?
because I got a Ring camera and I could look and see who was at my door. And then he said, why didn't you tell me about these things? So he bought one.
I move to introduce this photo.
Okay.
No objection.
Thank you.
Exhibit 8.
May I publish, Your Honor?
Yes.
Ms. Roberts, with the laser pointer, could you just point at the picture and show where the Ring camera is?
On this screen?
Yes, please.
Whichever one you can do.
Okay. Why isn't it working?
Nope.
It's on.
Okay, well, you know what, rather than use the pointer, why don't we describe, can you describe where you see the Ring camera on that picture?
It's in where the two lights are under the top window.
Okay, thank you. We could take that down, please. How many times would you guess you had been over to his house?
I don't know. More than 50,000. I don't even know. A lot. It was weekly.
That night, you told us that your husband went out to meet John at McCarthy's, a bar.
Yes, he did.
Do you remember your husband coming home that night?
Yes.
Do you have any memory of about what time he returned?
I'm guessing, but somewhere around 10, 10:30.
So I'm not going to let you guess. Do you know? Do you have it?
I don't know.
Okay.
It was around 10 or 10:30. I can't be exact.
Did you see him come home?
Yes,
What was the forecast for that night and the next morning?
there was a blizzard coming.
Was that part of the decision-making of going out or staying home?
Yes.
At that time, when your husband came home, did you look outside? Do you have any memory of what the weather looked like around 10, 10:30?
I remember
Like out that night?
the weather that night, I think was fine. It was cold, but it wasn't snowing yet.
I want to move forward ahead. At some point that night, did you go to sleep?
Yes, I did.
Did you sleep through the night, Ms. Roberts?
Yes, I did.
At some point, did you wake up?
Yes, I
No,
did.
she's still
I want
asleep.
you to tell us what was the reason that you woke up.
I got a phone call at 5 o'clock in the morning from Karen Reed.
Were you expecting a call?
No, I was not.
Had you ever received a call at 5 in the morning from Ms. Reed before?
No.
Share with us what happened that morning. What did you hear?
Karen called and the first thing she said was, Carrie, John's dead. And then she hung up. And then,
When she said that, did you have a chance to have a conversation with her?
no, I did not.
Describe her demeanor when she said that.
She was yelling loud enough, my name, I think it was 3 times, it might have been 2. She was yelling loud enough that she woke my husband.
Your husband was sleeping next to you?
Yes, he was.
Was she loud, yelling, screaming?
Yes, she was very loud. She was screaming.
After she said, Kerry, John's dead, did you know what she meant?
No,
And did you say this was around 5:15?
this was at 5. She called me at 5 on the dot.
After she hung up, what did you do?
I was half asleep still. I didn't know what was going on. So I started to get up and I think I tried to call her back. I know I tried to call her back, but I don't know exactly when because I was like, what? So my husband said, what was that? I said, I don't know. Something's going on. I don't know what's going on. That was Karen. And then I tried to call her back. I know I tried to call her back, but I don't know if she answered or if she called me back the next time I spoke to her.
After you or she called you again, did you have another discussion or did you hear her say something else the second time you spoke to her?
Yes, the second time she said, I think something happened to John. I think he got hit by a plow. He didn't come home last night. Kaylee was home. He would never leave her by herself, and I was not supposed to stay at the house last night. So I think something happened to him.
Did she say anything about drinking?
Yes, she said, we drank so much, I don't remember anything from last night. And I said, okay, where are you now? She said, I'm driving. And I said, you need to go home. Where's Kaylee? And she said, at home. I said, you need to go home and be with Kaylee. She cannot handle this, thinking, her uncle's missing. I said, you're going to get a DUI. You need to go home.
Was there anything else in the conversation that she said to you at that time?
She said, I'm going to drive to your house. Would you drive my car? And I said, yes. So at that point, I started to get dressed. I turned on the automatic car starter so it would warm up. Told my husband, I don't know what's going on. John didn't come home. And so I think my husband tried to call him and I tried to call him. And my husband said, you're not going anywhere. It's a blizzard. He's probably on somebody's couch. And I was like, I know, but she's really upset. I'm just going to go. She wants to come here. I'm going to drive her car. And then I went out to my car and sat and waited for her.
When you called John, did you get any response?
No, I did not.
As you were waiting for the defendant, did you make any other phone calls?
I did. When I was in the car, I thought to myself, well, she thinks he got hit by a plow. I'm going to call the police and see if there was any accidents or maybe something happened. They brought him in. And I spoke to the officer who said, no, nothing of that sort. I've been here all night. And then I called the Good Samaritan Hospital and Milton Hospital to see if they had anybody that was taken in an accident.
When you called the police to look for Mr. O'Keefe, did you call 911?
No, I called the non-emergency line.
Do you know if that call was recorded?
I believe so.
I'd like to introduce an exhibit.
Okay. Any objection?
No objection.
Okay.
When you, what was your level of worry at that point?
I wasn't super worried. I mean, he didn't come home, but they were out drinking. So I assumed, like my husband said, he's probably on somebody's couch.
The second call you had with Miss Reed. Can you describe her demeanor in that second call?
She was frantic. She was frantic. I mean, she was.
How soft or loud was that phone call?
It wasn't.
With court's permission, I'd like to play the exhibit of the call.
Okay.
Hi, friend said, calling because my friend's boyfriend did not come home last night. They were at waterfall. And now she is calling me hysterical because she doesn't know where he is. You didn't take anybody outside the name of John O'Keefe, did you?
John O'Keefe?
Yeah, he's the Boston cop. And
No.
he probably got a ride and passed out at some house. I don't know, but.
Yeah, no, we didn't lock anybody up or anything like that. And where does he live?
He lives on Meadow, down the seven.
He lives on Meadow, Pleasant. Okay, and where's the wife home? You said your girlfriend?
With his girlfriend, yeah, they were out having drinks, and then she left and expected him to come home at some point, and he never did.
Yeah.
And so I said to her, my husband had been out with him earlier in the night, but then he obviously came home. And he has custody with me to nephew because their parents passed away.
Okay.
And so she's home with the niece and nephew, and they're old enough to be home. And so she's nervous because she never even called.
Yeah.
So she's like, I feel like something happened, and I said, okay. Well, so call the area hospital and nobody got in. I personally think he probably picked him up and he passed out. I don't know.
Yeah, where did he didn't drive last night?
No.
No. Okay. Again, it's more, it's be driven by you. She would have to, call in a conversation and talk to us. But I mean, as of right now, it's more, he just didn't come home last night. Is this common sometimes?
Yeah.
Happen with him?
No, that's why.
Yeah.
So he didn't tell me. That's kind of why she's more freaking out. But like I said, it's not complete stop, we're gonna go back to people, if anybody couldn't pick them up.
Yeah.
We get it off.
Okay.
Again, we're gonna have a little bit of party and stuff.
Yeah, no, that's not now. Unfortunately, I wasn't there, I was stuck here. But we didn't get any calls, anything like that. Nobody was arrested or anything like that. All righty.
All right, well, thank you.
All right, no problem. Good luck.
Okay,
See ya.
thank you, bye-bye.
Were you in your car when you called the police station and the hospitals looking for John?
Yes, it was.
Do you know at that point whether anybody else had called the police station?
No, I don't know.
Do you know at that point if anybody else had called any hospitals?
I don't know.
How long did you wait in your driveway?
I don't know. I'm sorry.
Okay.
Maybe like 7 minutes, 8 minutes.
What were the conditions like out that morning?
It was bad. It was in the middle of a blizzard.
When you were outside in your car in the driveway waiting, describe the lighting conditions for us.
It was still dark out. It was 5 o'clock in the morning and it was snowing. So it was not great.
How was the visibility?
Not great. It was coming down really fast at that point.
You said that night when you went to bed, the snow just started. Had snow accumulated at that point?
No, I don't think so. It was just starting to stick.
I'm sorry, that was the night before, but at this point when you were in the driveway, had the snow accumulated?
Oh, yes.
Do you know how many inches it was?
No, I don't.
Okay.
Enough that the plows are out.
As you were waiting for the defendant, did she arrive at your house?
She did not.
What happened?
Again, I don't know if I called her or she called me, but eventually we connected on the phone and she said, I said, where are you? I'm waiting. And she said, I'm at Jen's house. And I said, Jen, who? And she said, McCabe, she's going to drive my car. And I said, okay, well, listen, they don't want cars on the road because it's so bad. I'm already in my car. I'll come there to Jen's house, stay there, and we'll follow each other and we'll go back and drop your car off. Did you look in the house for John? Could he just be in the house, passed out somewhere? And she said, no, she hadn't looked in the house. So I said, okay, now I'm going to come to Jen's. We're going to take the car home, drop it off. We'll check around the house. And then I don't know what the next step at this point was. I just wanted to check the house.
At the time you directed that you were going to meet at Jen McCabe's house and then drive to John's house, was there any suggestion by the defendant where she wanted to go?
I didn't know where Jen's house was. I knew the street. I had dropping Kaylee off or picked her up a few times. So I said, stay on the phone with me. So I don't know which house it is. And so when I got there, I pulled in the driveway and there was some conversation about.
Can I back you up and just ask you a little bit about the drive there? I don't mean to interrupt. When you left your house, you talked a little bit about the weather conditions. How long did it take you to get from your home to Jen McCabe's?
Oh, it's quick. Probably 4 minutes.
What was the driving like?
It was not good driving. That's why I didn't want two cars on the road.
Did you have any difficulty driving through that storm?
No, I mean, it was treacherous, but I was in four-wheel drive. I have an SUV.
You mentioned you didn't know exactly where Jen McCabe lived. Had you been there to drop off John's niece before?
Yes, but I didn't know which house it was because when I picked her up before, she was either getting out of the car at the driveway or waiting at the end of the driveway. So I didn't know which house it was.
I think I interrupted you, but were you telling us that as you drove to Jen McCabe's house, you were on a Bluetooth, on an open conversation with her to help with directions?
Yes, Jen and Karen were in Karen's car, and I was on the phone essentially with both of them.
Do you know what type of vehicle the defendant was driving at that time?
A Lexus SUV.
As you drove over to Jen McCabe's home and you had some guidance finding it, did you hear any conversations in that open line with, or even any statements by the defendant?
I remember when I pulled in behind her car in Jen's driveway, and at some point Karen said, my taillight, and I looked, and Jen she must have had the brake done because you could see that there was missing taillight.
When you say missing taillight, was it merely cracked?
No, there was a piece missing.
Could you see that as you were parked right behind the defendant's SUV or Lexus?
She must have been applying the brakes because you could see it, but there was a lot of snow.
When you saw that the taillight had a missing piece, did you say anything?
No,
Did you think anything of it?
no.
How long were you parked behind the defendant's Lexus while it was parked in Ms. McCabe's driveway?
Not long. We were just, I pulled in and then we stopped. And then the next plan, at some point in that conversation as well, or maybe on the ride, because now we're heading to John's house to drop a car off. I pulled out of the driveway, Jen pulled out, and I followed behind all the way to John's house. And at some point, Karen said, I left him at Waterfall. And I heard Jen say, no, I saw you pull up in front of my sister's.
Was anything else said about the broken taillight?
No,
You followed Ms. McCabe?
yes,
Where did you go?
to John's house.
Did you arrive?
Yes,
I want to ask you some questions about when you arrived and what you did next.
okay.
When you arrived at Mr. O'Keefe's home, you're in two separate cars. Who pulled into Mr. O'Keefe's driveway first?
Jen pulled Karen's car in first.
So Ms. McCabe was driving the Lexus
Correct,
and the defendant was in the passenger seat.
yes.
After you both pulled in, tell us what happens next.
We went, I wasn't sure if it was, at some point Karen showed us the taillight up close, but I didn't know if it was when we arrived or when we left. But we went into the house to look for John.
When the Lexus was parked by Ms. McCabe in Mr. O'Keefe's driveway, was it facing the street or facing away?
Facing where the basketball hoop is, not facing the street.
I'd like to approach.
Okay.
Going to show a photograph. Do you recognize what's in that photograph?
Karen's car on the left and John's car on the right.
Do you have both those cars?
Yes, I do.
Do you recognize that photo as a fair depiction of his driveway?
Yes,
Do you recognize it as a fair depiction of the motor vehicles?
yes.
Now, when you went there that night and you pulled in behind Ms. McCabe and the defendant, is there any differences between how that area looked when you pulled in as opposed to that photo?
Well, it was the early hours of the morning, so it was dark out and there was much more snow. And there was
Other than
snow
this-
coming down.
I'm so sorry. You want to finish?
Nope.
Other than the snow and the lighting, is there any other differences?
Nope.
I'd like to introduce this as an exhibit, please.
All right. There's no objection, Mr. Jackson.
No objection. With the court's permission, I'd like to publish.
Okay.
And to help us understand, you see on the left is the house.
Yes,
There's a motor vehicle in the middle of the driveway, but it's the vehicle to the left.
yes.
And whose vehicle is that?
That's Karen's.
Is that where it was parked that night when you went into the house?
Yes,
And the motor vehicle to the right, you recognize that?
that's John's car or SUV.
Thank you, you can take that down. I'm showing you a second photo.
Okay,
Do you recognize that photo?
yes.
What is it?
It's the back of Karen's car.
Does it look like a fair and accurate depiction of her car as it appeared that morning in the early morning hours?
Yes,
Do you notice anything that's distinguished in that photo?
the piece that's missing in the taillight.
Which one?
The right passenger rear.
Do you know when, I'm sorry, do you know when this photo was actually taken?
I do not.
Although you don't know when it was taken, is that a similar depiction to your memory of how it appeared that morning at 5
Yes,
or a little after 5?
yes.
I move to introduce this exhibit.
Okay.
No objection. The court's permission, I'd like to publish.
Yes.
We can take that down, please. After you arrived at Mr. O'Keefe's house, what was the plan to go inside? What were you looking to do?
To go inside and look and see if he was passed out somewhere. So we went in through the garage and I started looking I think Jen ran upstairs to Kaylee's bedroom, and I just started looking through the living room. Basement door was locked from the inside, so I knew he wasn't in the basement. And then I checked the other living room. He has a big house. Then I went to the top of the stairs to check his bedroom.
As you looked around, what was your mood?
What was my mood?
Yes, were you calm?
I mean, I was worried. So we were, at this point, Jen had already established that they went to her sister's.
Sustained.
Okay.
Jen had already.
No, let me ask
hold
the
on,
question.
Ms.
I'll ask
Roberts.
the question better. My apologies. How many rooms did you look through in John's house?
1, 2, 5 or 6.
Did you see Miss McCabe looking in rooms as well, searching?
She went upstairs when I was looking downstairs.
At some point, as you were looking, did you see the defendant?
Yes,
Was she looking with you?
she was in John's room.
What was she doing?
She was just standing there when I came up to the top of the stairs.
Did she say anything?
No,
Did she do anything?
no,
Was she searching?
I don't know. She was in the room.
What happened next?
At some point, Jen earlier had said,
Well, let's not talk about what was said. Okay. Let's
Well,
just talk about
the plan
best
at
you
this
can,
point
your-
is
your
to go to
memory of what was
34
done.
Fairview.
Ms. Roberts, I know that I'm just going to ask you to wait for a question
Okay.
because we can only get one person at a time. So next question, Mr. Brennan.
Again, my apologies. And so as you're looking through the house, you don't find John. What happens next?
the plan was to go back to Jen's sister's house.
Who made that plan?
Karen wanted to go back there.
Well, tell us a little bit about that. How did that conversation come up, and share with the jury what was said?
And the car ride to Meadows, Karen said, I left him at Waterfall. And Jen said, no, I saw you pull up in front of my sister's. So then Karen said, we need to go back to your sister's. And I said, no, we're going to go to Meadows and we're going to drop the car and we're going to look there. Then we'll go there if we don't find him.
When you were at the house, Meadows, John O'Keefe's house, and you didn't find him, was there any further conversation about what the next steps would be?
I said, let's go. He's not here. But I didn't know where Jen's sister lived. So we got into the car. Jen was in the passenger seat. I was driving my car. Karen was in the back seat.
Did you
And Jen
begin,
was giving directions.
did you begin your way towards Meadows?
Yes,
And it was Miss McCabe who was giving directions?
yes.
As you began driving to head towards Meadows, in addition to trying to drive, were you doing anything like looking or searching?
Well, yeah, we were looking on both sides of I was looking on both sides of the road in case he was walking home.
Did you see Miss McCabe searching?
Yes, she was looking out as well.
Describe a little detail about what you saw Miss McCabe doing.
She was looking out the window as we were driving. So was I, as I was driving.
And where was the defendant during that time?
She was in the back seat.
Was there any conversation, comments, statements?
Well, she would be in the back seat and then she would be in between Jen and I, in the back seat and then in between Jen and I. She was just very frantic.
Okay. Was she saying anything?
Specifically, I mean, there was conversation on the way there.
Okay. Was she looking as well? Did you see her looking out the windows like you and Jen?
I don't know if she was because she was in the back seat.
As you drove to Meadows, what was the visibility? The same or better, worse?
No, it was poor.
Did you make your way towards Meadows?
I did.
As you finally got to Meadows, was the house on your left side, your side, or on the other side?
Are you talking about Fairview or Meadows?
I'm sorry, Fairview.
Okay. The Fairview house came up on the left-hand side.
Before you got to the house, is there a tree line between that house and the house before it?
Yes. There's a cluster of trees and bushes.
All right, take us back. I want to talk about that morning. As you're driving and approaching Fairview, tell us what you hear, what you see, what's happening.
Jen's giving directions, and it was really bad driving. I was white knuckling because it was getting slippery. Karen wouldn't put on her seatbelt because she was in between us again the whole ride, and then sitting back. But she was worried because we weren't finding John.
Were you having words?
Yes.
Tell us.
I said to Jen, where are we headed? And she said, my sister lives on Fairview. I said, where is that? She said, off of Chapman. I said, oh, okay, near Spring Lane. At some point, Bella's mom came up.
Tell me what that means.
I didn't know who it was, but it was one of Kaylee's friends, Bella's mom. Well, the directions, at some point, Karen was talking about Bella's mom to Jen, saying she never liked me. I didn't know who this woman was that they were talking about. But apparently, Bella's mom lived near where Jen's sister lived on Fairview.
Did you learn any more about the relevance of Bella's mom?
No. Oh, well, I think John had dated her.
I'm going to allow it.
So as you approached Fairview, tell us what happens.
As we approached Fairview, at the house. You mean the house or the street?
Yes, the house.
The house. Jen said, my sister's house is right up here. And I said, okay. And as we approached the house, Karen from the back seat is now screaming, there he is, let me the F out of this car. And she's now kicking the back door to get out.
When you heard the defendant scream, there he is, and started kicking the car door, did you see anything?
I did not.
Did you see anybody?
I did not.
Did you look?
I looked.
Was there anything that impeded your ability to see far?
No, it was just snow.
How far could you see when she was yelling, there he is?
How far could I see?
Yes.
I mean, the visibility wasn't great.
Okay. Was she pointing or giving any direction?
No, she just said, there he is.
Okay. What happens next?
And then I unlocked the car. I looked over, I didn't see anything. And I unlocked it so she could get out of the back seat. I looked at Jen and I said, she's crazy. And then I turned around.
When she started running, before she got anywhere, did you see anything at that point?
I did not.
Were you looking?
I was looking. She said, there he is. So I'm looking around to see where he is.
And you could see nothing?
I did not.
Did you see her run around or directly?
She ran right over to the mound of snow.
Could you tell what the mound of snow was from the car?
Once she got to it, yes, it was. Once she got to it, you could tell it was a mound of snow that was the length of a body.
All right, I'm going to stop you there, Mr. Brennan. I need to see counsel at sidebar for just a minute, please.
Why did she need to see them at sidebar all the time? Karen gets to go up there with them now? Cool. Paul, quit side-eyeing her. She did not kill your brother.
All right, so Ms. Roberts, we're going to have you come back tomorrow for today. So we're going to send you the same that I'll tell you every single day. Please do not discuss this case with anyone. Don't do any independent research or investigation in this case. If you happen to see here or read about this case, please disregard the letter. Please be extra careful with your social media. Okay? We'll
Why
see you
are they in?
tomorrow. Thank you.
Court, all rise, please.
Early. 6 weeks is going to turn into 12 if you keep doing this crap. Why are we doing this? No, don't cut away. They got motions to talk about. Court TV. So you roll.
Jimmy, those motions done, please.
Graveyard.
Compliant with order. and the motion to continue. All right, thank you.
Thank you.
Sorry, Chrissy, I didn't mean to do that.
What? That was it? They're not going to go over. I thought they were going to go over the other motions that they talked about this morning. Seriously? So what did she just say? What did she just say about the ARCA motion? I'm tired. And I'm almost glad I have to turn my camera off. How? Seriously. How many different times did he ask Carrie Roberts, tell us about your relationship with John? Are you asking her more? She just did. God bless America. How'd you help him out with the kid? She just told us. Just told us. Don't ask her again, Hank. Let's get on with the pertinent questions. So, oh yay, Verdict Watch. An hour and 45 minutes. What was I going to say? I guess so. Same questions over and over. Literally. I had a thought. Oh, so why is the insinuation? I'm assuming the insinuation is because she saw him in the snow and nobody else did. The insinuation is that she knew he was there because she put him there. Is that what that's supposed to be? I don't buy it. No, she was looking for him. She was looking for him. They were looking for him walking along the side of the road. She was looking for someone that had been hit by a snowplow. She was looking for someone that could have been passed out in the snow. That's why she saw him when he was covered with snow. That's not what they were looking for. They were looking for somebody walking on the side of the road. So I don't buy that. And Carla, you're gonna find out that little tiny piece that was missing when the lab people, if Brennan does it like Lolly did it, and when they get the lab people up there and they show all of the pieces of the taillight. Okay, think about when you break a glass or something in your home and it shatters. You can never find every single little bitty piece to put it all back together, right? They put this taillight back together. except for one little tiny piece circle in the middle. Because that's the piece she lost when she hit John's car. But every other piece they recovered. And yeah, she was more desperate to find him. Yeah. Well, the thing is that Hank is gonna want hearings before experts testify and stuff, and he's gonna drag it out, and then when I don't like the way he questions. It's better than Lally. It's still better than Lally, but tell us about yourself. No! We don't care! Just start asking relevant questions. We don't need to like them. We don't need to know. I'm sorry, I'm getting loud. We don't need to know what they do for a living, how many kids they have. We don't need to know. We don't need that. If they're not an expert, we don't need to know their training, where they went to school, blah, 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 blah. We don't need to know. Just ask some questions. This is a long trial with a lot of witnesses. We don't need to know all that. And I'm not being rude. If it was a shorter trial with fewer witnesses, we could do that. We could be nice and courteous and tell us about yourself. But not in a trial like this. It's too long. There's too many people. No, we got to whittle down where we can. And that's the area that we need to whittle down. It's going to take forever. And then why? Why are you quitting? It's not even 4:00 yet. Why are you quitting so early? Go watch Judge Judy. Whatever. No. I'm gonna go take a nap. Okay, guys, I will see you in the morning. We will continue with Mr. Eyebrows in the Phil Spector trial. It's day 1 and I'm already slap happy, y'all. Like I said, I'm kind of glad that I have to turn my camera off. And then I gotta show you when I told Jill to behave. I had just put dude. I used our dude emoji in the chat. She sends me this and says, even my Coke is aggravated. And I didn't know, because this is the one thing we don't have in common, Jill. I drink Pepsi. So I didn't know they came like that. I thought they just came with names on them. So I was like, why does it say dude? That's not a name. I was like, why did your Coke say dude? And she says, so I can poke fun at you. That's why I was like, behave. Yes, it does. It does. It does. It makes them more of a person to the jury. But this trial is so long. When did it start? It went through July last time. When did it start? I used to drink Coke, and then I had a bunch of friends that drank Pepsi. And so every time I went to their house, I had to drink Pepsi. And so I just like switched over. Now everybody drinks Coke, and I'm one of the weird ones that still just drink Pepsi. When did it start? Did it start in April last time? Or did it start earlier than April? I can't remember. But it seemed like it went on forever. What was it, like 9 weeks last time? It was long. It was a long trial. Do you guys remember when New Coke came out? Because they were trying to compete with Pepsi. Because back then Pepsi was like number one. So it tasted like Pepsi, which was, you're right, flatter. So we had the youth group at church. We went to this thing at a church in another town, and I don't know if it was just our youth group and that youth group, or if there was another church that went. I don't know, but they had this contest, and it was like a blind taste test to see if you could tell. The youth pastor went I drink diet, so the youth pastor went all over Gainesville looking for Old Coke, because it was right after they switched. So he went all over Gainesville looking for Old Coke. So it was Old Coke, New Coke, and Pepsi, and it was like a blind taste. And it was whoever could figure it out. So it was me. The only people that could tell was me and the pastor's son of the church that not our church, but the church we were doing it with. And then they put just two of us, just me and him, because we won the first round. And they just gave us, no, it wasn't clear. It basically, they changed their formula so it would taste more like Pepsi. And then they backtracked and went back to the old Coke because it didn't do well. So then for like the final round, because he and I both, so we tied because we were the only ones that could tell the difference. Then they gave us one. I don't know why they did it. I guess because Pepsi was number one back then, so they wanted to compete by making it less fizzy or whatever. I don't know. So they gave us just one, and we had to be able to tell without tasting all three what that was. And I got it wrong, so I lost. But the pastor's son got it right. And then afterward, so he won. I forgot what he won. Like a gift certificate to a Christian bookstore or something like that. But he won, and then they told me, well, he's been practicing all week. Because the church was the one that was putting on the contest, so he knew about it, and he'd been practicing, and he won. I'm like, that's not fair. That is not fair. I drink diet, so I think, like, when I go to restaurants that don't have Diet Pepsi, which is most restaurants now, I'll drink Coke Zero. I like Coke Zero, but like Diet Coke, I don't like, because I don't know, it's the diet part of the Coke that I don't like though. But Coke Zero is good because it just tastes like regular Coke to me. But I'm used to diet. That was clear, wasn't it? Crystal Pepsi was clear, right? Did it? I remember it, but I don't remember what it tasted like. Did it taste like Pepsi? Was it just like clear to like get rid of the color the chemicals it colored and stuff. Yeah, I barely remember it. I mostly drink water though. I mean, you guys see me drinking water all the time. I mostly drink water. But I've got Diet Pepsi in there. And Travis drinks root beer, and I accidentally got him diet root beer this time. So, and he used to drink diet root beer, but then he started getting regular root beer again. So I was like, oh, that's okay. You can drink the diet. And he's like, okay, I'll drink the diet. And then he drank some, and then he was like, no, you can have it. I don't want it. You need to drink the diet. It's better for you. It's not really better for you, but I love root beer. But officially, I'm not diabetic anymore. I'm pre-diabetic, which I don't know how I can go from diabetic to pre-diabetic, because pre means before. But but I still have to watch my sugar intake. So I do Diet Pepsi, Diet Root Beer, mostly water. But as far as like, I tried to do protein and low carbs, unless like around Easter I eat too many Peeps. I love Peeps. And when I order from Walmart because I get paid once a month because of disability. And so when you have to buy like a month's worth of groceries, which it really doesn't last a whole month, but anyways, to walk around Walmart that much is very, very hard for me. So when they started doing the ordering online thing, that's perfect. I'm like, okay, because I would go in there with the list and we get halfway through the list and I'd be like, I can't, Travis, I can't shop anymore. We have to go. But this is perfect because then he just leaves work and he goes there and he picks up the groceries and brings it back, and then I put it up. So it's perfect. Neither one of us get worn out that way. It's great. But sometimes I will accidentally push the button too many times. So I got like 8 boxes of Peeps and I didn't mean to do that. So I had way too many Peeps for Easter this year. Oh, wow. That would be horrible. I don't like Dr. Pepper. I've never liked Dr. Pepper. When we first got married, Travis and the girls drank Dr. Pepper like water. The girls still do like it. Travis started drinking root beer, and now he's a root beer person, but it tastes like... Wait a minute, it's Topamax? I'm on Topamax. That's my weight loss medicine. Thank God it doesn't do that with me. I have no problem at all with the Topamax. None whatsoever. But the other medicine they put me on for the weight loss? No, absolutely not. Absolutely not. It's called... Oh, I can't say it. Fin something. Fin something. I can't say it. Phentyramine, something like that. The first time we went... Now I will go into Walmart if it's not a big trip. We went to Walmart. We were in Gainesville on like when he has Saturday. He works every other Saturday. So a lot of times on Saturdays, If we need stuff that we can only get in Gainesville, we'll make a trip of it, and like Hobby Lobby. So we'll go to Hobby Lobby and then like Harbor Freight for because we don't have one of those way over there, and we'll do that. And then we'll run into the Walmart over there while we're there. So we have been doing stuff, and I've been pretty okay. But then by the time we got to Walmart, I'd started feeling kind of strange. But we got to Walmart, got out of the truck, and I had to immediately sit back down. So I'm on the ground in the parking lot. And Travis is walking, he turns around, he sees me, he goes, "What's wrong with you?" I'm like, "I don't know." I don't know what's wrong, but something's wrong, but I don't know what's wrong. And you know me, I laugh at everything, right? I've been that way my entire life. Everything is funny, which I guess is a good attitude to have when you have as much wrong as I do, right? So I'm laughing. I'm down, I'm on the ground laughing, and Travis is like, "What's wrong?" I don't know, but I'm laughing, right? So he's like, "Well, get up and come on." "I can't, Travis. I don't know what's wrong, but I can't." So he's trying to pull me up. I'm laughing. My legs aren't working. I don't know what's going on. So he finally helps me get up. He's like, I'm leaning on him. He's got my arm. We're walking in. I get a buggy because there's no scooter thingies. And I'm leaning on this buggy. I'm like wrapped around the push thing so I don't fall down. And I'm just like, I'm like Tim Conway in the Old Man sketch with the cart, just barely moving, just barely moving. And he goes, "I'm gonna go over here and grab this real quick." And I'm like, "Okay." And like by the time he gets back to me, I've moved like 3 feet maybe. And so the next appointment that I went to my weight loss doctor, I'm like, "I stopped taking that, okay? Because I can't walk." He's like, "Okay, that's fine. A lot of people can't tolerate it." I'm like, "Okay, good, because I'm not taking it anymore." So, yeah, that. In fact, back in was it the 80s or the 90s? I don't remember. There was a weight loss. It was like a combination. It was 2 drugs together, and they called it Fin, but it was 2 drugs. One was Fin something, and the other one was Fin something. So this is one of. Oh no, it was funny. It was funny. Of course, I'm embarrassed while I'm in Walmart, but at the same time, I think it's hilarious. So I'm embarrassing myself, but I'm thinking this is too funny. I can't. I'm like, if somebody were to jostle me right now, I would fall on my butt right here in the middle of Walmart. Oh wait, did I put up the wrong one? That one. Yes, I am glad your knee is better. Very glad your knee is better. Unfortunately, those injections do not last forever, but just keep going until they don't work anymore. That's what I do. Or that's what I'm going to do, I should say. Because so far they still work. But yeah, that weight loss medicine, no, absolutely not. In fact, I think I called. I don't even think I waited until my next appointment to tell them I quit. I think I called them and told them I was quitting it. Because I was like, no, if I get out, and immediately, as soon as I got out of the truck, like I walked around, because I didn't actually sit in the parking lot. It was like where the trees are, the little like build up step thing where they have the grass where the trees are. I sat on that. I was still almost on the ground, but it was like we parked next to it. So I just got out of the passenger side and walked around and then flop down on the ground. Travis didn't even notice. He just kept walking. And then he looked back and like, "What are you doing?" I'm done. I can't do this. We're done. Let's go home. No, what are you doing? Oh, yeah, that was fun. But I've had no problem at all whatsoever with the Topamax. And they put me on that for my migraines, and it didn't work. Not a bit. And I lost 30 pounds, and they took me off of it. They took me off of it, and I was like, no, I lost 30 pounds. You have to keep me on it. And they're like, well, no, it was for your migraines, and it didn't work. So we have to put you on something else and take you off that. I was like, but can I be on both of them? And they were like, no. And then they were going to put me on Ozempic, but it was going to be like $400 a month. And I'm like, no, I cannot afford that. I cannot afford $400 a month. That's ridiculous. And so then they're like, oh, well, we have other medicines that we can put you on. And when they told me they were going to put me on Topamax, I was like, oh, yes, please. Thank you. Yes. That works. I know it works because I've been on it before. So it works. But now I'm going to have to go off of it because they're going to try me on a different one. Really? I didn't know that was one of the side effects. Everything's a side effect. I think any medicine can do anything to anybody, no matter what. It's just different with different people. Like, gabapentin, I had taken it the first time I took it. Didn't bother me at all. It was wonderful. And then I can't remember why they took me off of it. Y'all, I was a preemie. I wasn't done yet. I was born at, I don't know how many weeks, but 7 months. So I wasn't done yet. And I've had physical problems my entire life. So they have had me on medicine and taken me off medicine and tried different medicine. And so I don't know why they took me off the gabapentin the first time. But I didn't have any side effects, any problems, anything. Then the second time they put me on it, I was ready to myself. I had a nervous breakdown. I didn't go. Yes, I definitely am. Absolutely. I definitely am. But gabapentin messed me up bad. And I was trying to figure out because there was like no reason for me to be like just off my rocker. I was like, why do I want to leave this mortal coil so badly right now? What is happening? I was like, okay, so what is different? And I realized that's the only thing that's different. That is the only thing that's different. It's got to be that. And I quit taking it and I got better. So I was like, oh my gosh, that's bizarre. Because the first time I took it, it didn't do anything. So, side effect wise. So, yeah, it does different things. I think any medicine can do different things to different people. Yeah. See, the first time I took it, it did great. Absolutely great. And I forgot why they took me off of it. It might have been even a copay issue. Like it might have gotten too expensive and I couldn't afford it anymore. I don't even remember why they took me off of it. And then they went to con it and I was just ready to. I scared Travis to death. Oh, yeah. There's lots of drugs that'll make you do that. But I mean, this was bad. Like I was even thinking of ways to do it. And knowing that I would never do it, but still I had those thoughts, even though I would never do it. But still, I was thinking of ways, even knowing, and then like I've told my doctor before, and Casey, my stepdaughter, I had this conversation. She's like, do you know that you can be ascital? I don't want to say it without being that. I was like, how can you be it without being it? And she said, because you think about it, but you don't do it. I was like, what? And she goes, yeah, you think about it, but you don't do it. And I was like, I have that. I have that. So then I said something to my doctor about it. And he says, yes, it's called passive ideation. I was like, oh, because I told him, I said, I would never do it to myself, but if it happens, and I don't care. And he's like, that's passive ideation. I was like, oh, that's what that is. But I don't have it anymore. I'm fine now. Yep. Yeah. And Travis is healthy as a horse. He thinks that all of this stuff, like medicine causing side effects, that that does stuff that then you need other medicine for or other treatment for, that's all big pharma, that they do that on purpose. Bye, Terry. Um and I don't know, maybe it is. Who knows? Now, you guys, I tell everybody this. You need to get one of these. Get one of these. Now, if you have like an anatomical thing in your brain that causes migraines, they're not going to work. Well, I shouldn't say that. They might. But mine, I don't have a cause for mine. They ran tests, they've checked all of my nerves, they've done all kinds of stuff, tried me on all different kinds of migraine medication that sometimes they work, sometimes they don't. Now, this is back before all the new stuff came out too, though, because when did I get this? I can't remember. It's been so long now. I've probably had this earring now for about 10 years. Has it been that long? Yeah. Yeah, about 10 years. And it works. I have not had a migraine. I still get headaches, but I have not had a migraine. I had a migraine when I had pneumonia, but that was because I had pneumonia. Just like a symptom of pneumonia, not because of anything else. But because they run in our family, they're hereditary. My cousin got one first, and she kept telling me to get one and telling me to get one, and she said it worked for me. It's called a doth piercing. It goes in. You can't. It's so in my ear you can't see it. Really see. It's this part. It's like the inside part of your ear, right there. I don't know if you can see it on the camera. It's Daith, but it's pronounced doth. And it's like a pressure point, like an acupuncture pressure point right there. But you pierce it and then it stays constant and it keeps your migraines away. And my only regret is that I didn't get it sooner, because I used to have weekly migraines that would sometime last days. I've had them last weeks. Really? Oh my God. Oh my God. I would be pissed because that hurts like hell. Because when I had the migraine, when I had pneumonia, I thought it didn't work anymore. And I was like, if I have to get another one in the other ear, I'm going to cry. Like, I don't ever want to have that again. I shouldn't say that. Actually, no, it's worth it. Because, I mean, the pain is gone as soon as it's done. It's much, I mean, it's done and done. You know, it hurts and then it's done. And you won't have any more migraines. So, but I mean, I can't promise that. Like, if you've got some type of a, you know, neurological thing going on, you might still have migraines, but it worked. It worked good for me. So I am pleased as punch with it. Like, no regrets. Like I said, the only regret is that I didn't do it sooner. I'm talking missing work. When I was a kid, I missed school. In bed for a week at a time with a migraine. You know, migraines that lasted for days, like big time, like puking, passing out, bad migraines. Yeah. Like vision, you know, messes with my vision, vertigo, super bad migraines, and nothing now. So now headaches, I still do have headaches, but not, you know, like I told you guys last weekend, I had a headache, like, and I had a headache on Friday, but I was here with you guys on Friday. You know, like, it doesn't stop me. It's just a headache, aggravating headache, but it's just a headache. You know, I can still function. It's not a migraine, but so yeah, and I got it. When did I get it? Well, 10 years. No, it wasn't quite 10 years. I was in my late 40s. So not quite. I think I was like 48 and I'm 56 now. So not quite 10 years. Because I remember thinking, I'm almost 50 and I'm going to get this weird piercing in my ear. That's going to be weird. An old lady getting a piercing in here of all places. You know, because you have to go to a tattoo shop and everything. But oh. I've not had any that bad that give me like stroke symptoms. That would be scary. That would be super scary. You guys, I got a new nose ring yesterday. Can you tell what it is? It's bigger than my other one, and you still can't tell what it is. I don't know. I'm not used to having one this big. It's a paw print. Can you guys tell what it is? Is it too big? I'm too old for all this crap. I don't know why I do it. I was gonna grow old gracefully, but I wanted my nose pierced so bad. Travis wouldn't let me do it when back when I was immunosuppressed, because every little thing that bit me got infected, and he said that's your face, and if it gets infected, you're gonna lose your nose. So he wouldn't let me do it. So then after I got where I wasn't immunosuppressed anymore, I got one of those little ear piercers and I did it myself. It was really easy. But now, when I was a pediatric nurse, I had patients that had like eyebrow piercings, and I'd be like, Oh, that hurts me just to look at it. Don't. Don't. No. I wore fake ones before I pierced it myself. I wore fake ones to make sure I was going to like it. And they had, I think I got them from Temu. They were like fake. They were like rings that just like stuck up. You just like stuck them in your nose. Yeah, you can't really tell that it's big, but you still can't tell that it's a paw print. I was like, why does it have to be so big? You still can't tell what it is. I didn't realize it was going to be that big, but oh well. I have a hoop, but I stopped wearing it because I have a habit of playing with it. And then it looks like I'm just like playing with my nose. So I quit wearing it. Well, I hope I'm not too old. I was gonna like grow old gracefully and quit coloring my hair but then Travis kept saying like I'd get it cut and it'd be really pretty and Travis would go, well, I need to do something about the gray. And I was like, what? So I want to get another because I have that one. I want to get a phoenix on this one. Let's see if I can find the picture. Because I'm a chicken, so I don't want like anything super huge and super detailed. But I want it in red instead of the black. Because this was for my, I thought this was more like over here, but it's not. It's over to the side. Because that was for my first cancer emission. So, put the phoenix there. It says "Still I Rise" for the second one. But I don't have that kind of money. Oh, that's cool. That'd be cool. My stepdaughter has a gorgeous scorpion. She's a Scorpio, and a gorgeous scorpion on her arm with like the constellation behind the scorpion is beautiful. And I was like, "Oh, cool! I like your tattoo." And she goes, "Oh, thank you." She goes, "Mama got mad." I was like, "Why?" She said, "Because it cost $300." I said, "You paid $300 for a tattoo?" She said, "Yeah." I said, "Oh, well, I guess it's okay. You don't have any bills." She goes, "I have bills." Well, what bills do you have? Well, I said, "Yeah, you pay your car insurance." Yeah. And I pay, and she rattled off some stupid couple little somethings. I don't even know what it was. She still lives at home with her mom. She doesn't have any bills. And she's 30. Must be nice. Yeah, you have fibro that hurts just like to touch or to have like tight clothes on. I'm a little, I guess, a little more fortunate, I guess I should say. I don't have the touch thing. So I'm a little more fortunate. I can't stand tight clothes though. Tight clothes. Mm-mm. No. Like, I'm trying to get, now that I've lost weight, you guys haven't seen this shirt before. This is my Tower of Terror shirt. Yesterday, I had my Princess Leia shirt on. I'm trying to get older shirts out of the back of the closet that I couldn't wear before. So they fit me now. Perfectly fit. They're not too tight. They are just perfect. And then all my old shirts are way too big for me. But I mean, they're comfortable. I still wear them. But I can't stand tight clothes, and that's a fibro thing. But it's like some people with fibro, they can't even like be hugged. Like a hug will hurt. My dad used to do that thing. Biggins talked about it, the chomping corn thing, where you grab someone's knee, and like a horse chomping corn. My dad used to do that to me all the time. And I would be, Dad, stop, that hurts. I didn't hurt you. And he did that for years and years and years. And then when I was diagnosed with fibromyalgia, he'd do it, and I'd say, Dad, stop, that hurt. And he'd be, oh, I'm so sorry, I forgot. I'm so sorry. Like, he did a total 180 because he realized he had been hurting me all these years. He felt so bad because that type of stuff does hurt. Whereas somebody else, you're just playing with them, it doesn't really hurt. But with me, it did really hurt. So it depends on the amount of pressure. So I don't need, like, light pressure doesn't hurt, but a lot of pressure on joints is very painful. I twisted my ankle playing vodka last night. I don't know what that means. I don't think I've seen that. I used to collect unicorns, but I ran out of room for them. My collection is scattered. I think I gave some to the girls. I think I sold some. I don't even know where they all are now. But I ran out of room, so I started parsing them out to people. Might have some around here somewhere. I don't even know. I don't think I've seen the last unicorn. It's a Rankin and Bass. I thought they only did Christmas. Is it a Christmas? Why do I not remember that? But what are you congratulating me on? That I'm not as sick as you? No, don't congratulate me on that. That's not, I don't want to be congratulated on that. No, don't congratulate me. I don't want to be congratulated on that. No, don't. I have survivor's guilt really bad. Well, I know that's not a survivor, but I have it when it comes to cancer really bad, but I love dragons, I love unicorns, I like all that fantasy stuff. There's no way I can find this picture fast enough. Wait, did I buy it? If I bought it, I might be able to find the picture fast. I think I bought it. Did I buy it? I can't remember. It's a pattern for a pillow that I want to make because I'm going to have like a chair set up when I have my studio to put like a camera, and I'm going to make like a step get steps to go up to it for the dog. So maybe I can put a camera there and have like a dog cam. Oh. Did I buy it? I thought I bought it. I didn't buy it. Oh, shoot. I did my favorites. Why is it not in my favorite? Oh, wait. See y'all. Okay, this is gonna make me mad. Oh, well, if I had just done that. That's the crochet pattern I want. I want that pillow. I want to make that pillow. I love it. Isn't it cool? I want a bearded dragon. I've always wanted one for as long as I can remember. Winifred. Oh. Gollum still scares the poo out of me. I love lizards. I like lizards. I'm scared to death of snakes, but I love lizards. I love lizards and I love jumping spiders. I'm not afraid of spiders like other spiders. I don't have anything to do with. I like jumping spiders. I will catch them and let them crawl all over me. I have habitats set up and ready to go. In case I find one outside, I'll bring it in, and I have worms in the refrigerator that are ready to feed them. And I'll bring them in and watch them and name them and let them come out and crawl all over me. And then if they start to act like they're not doing well, then I'll put them back outside. I had one that lived for probably close to 2 years, and he actually died. Like, he did well, but he died in his habitat. The other ones, though, when they start to like get sluggish and stuff, because I've had, actually, I think he's the only one that's died in his habitat. He was fine, and then one day he just was dead. The other ones, they got weird, like they acted like they weren't doing well, so then I took them back outside. Yeah, the Hogwarts Legacy, that game, my stepdaughter's scared to death of spiders, like terribly, terribly scared. And there are spiders all over the place in that game. Like it even like rewards you for how many spiders you kill. Like you get every so often you get a prize for killing spiders. And there's several levels. Well, it's not really levels, but like dungeons or whatever, where you have to crawl under like ledges and stuff, and there'll be spiders. They don't hurt you or anything. They're just like there for the effect, but like as you won't see them, and you'll go to like duck under the thing, and then they'll run really quick, and it's almost like it gives you the heebie-jeebies. You almost feel like they're like running up your back kind of. And I was like, so Kristen, how are you doing with the game with all the spider? And she said, I had to run out of the room. I was like, Mommy. Said, I had to get Skylar to finish it for me. Skylar's her little 8-year-old niece. I was like, oh, yeah. A lot of spiders. Jumping spiders are sweet. They'll wave at you. I had one, she'd crawl up my arm. She'd stop. She'd crawl up and stop, and she'd look up at me and she'd wave. And she'd stop and she'd crawl and she'd look. And she'd look and she'd wave. And she was so cute. And then I tried to put her back in her thing. She wouldn't want to go. I'd be like, okay, Penelope, it's time to go back in your thing. No, she'd crawl back up. I'd finally get her on like the leaf or whatever, and I'd pull my hand out and I'd go to shut the door, and she'd jump back out on my other arm. Well, where is she? There she is. Look at how cute. Let me see if I can get a picture with her fangs. Her fangs are pink. See her little pink fangs. She's so cute. Jumping spiders cannot bite humans because their jaws aren't strong enough. Their jaws aren't strong enough to make their pinchers pierce human flesh. So a jumping spider cannot bite you. So there's no way they can hurt you at all. So that's kind of how I got rid of my fear of spiders, is with jumping spiders. They can jump, yeah, but they don't hurt. They just jump. And the older they get, the less they jump, too. When they're old, they don't jump hardly at all. Okay, I gotta go. Travis will be home soon. We're not having a fancy dinner tonight. I'm just gonna put some frozen barbecue chicken tenders in the oven and some sweet potato fries in the air fryer. I'm just going to have a lazy dinner tonight. Yeah, I'm terrified of spiders though, so I get it. I do. I get it. I hate spiders. I mean, I hate snakes with a passion. Absolutely. Oh, I didn't tell you guys about the time that there was a snake in the yard. It was in the winter. Snakes don't. I looked this up. I had no idea because I hate snakes. I don't know nothing about snakes. It's the only good snake is a dead snake, if you ask me. They brumate. They don't hibernate. They brumate, and that just means that they're sluggish in the winter. They're like sleepy, and they will come out to warm up, but they're still going to be super, super sluggish and sleepy. Yeah, I think they're beautiful. Some of them are really, really pretty. Ugh! Yeah, only from a distance, though. Yeah, that's, I think, the reason why I'm afraid of snakes is because when I was about 5, I was out in the yard with my dad. And my dad has a way of, or had a way of kidding where he could totally straight face, like tease you, but make you believe something. So he was like, Debbie, you're standing on a snake. I was like, no, I'm not. He's like, yeah, Debbie, you're standing on a snake. Look down. I'm like, no, I'm not, Daddy. Like, yes, Debbie, you are. Look down. And I looked down and I was standing on a snake. And I jumped off, and he had a little garden at the side of the house. And he took the hoe that he was using and cut the snake up into pieces. And it was still moving. And so I think in my little 5-year-old mind, I thought you can't kill a snake. There's no way to kill it. It just lives, even when you chop it up. And I think that's why it turned into a phobia, because that's what I thought about snakes, is that they just live forever. You can't kill them no matter what you do. Because I watched my dad chop up a snake and it kept moving. So anyway, so it was the winter, and this is when I had my Chihuahua. So I took the dogs out. I think I had the beagles on leashes, but not Link. So my poor Chihuahua. It was not a rattlesnake, but still, it was a snake. Stretched out, just out in the sun. I mean, just straight stretched out. So we go out there, and I, hold up with the beagles because I've got them on leashes. Link just trots right by the snake. Link. I'm just screaming, get back here. But do I run out there to save him? Hell no. And I'm just crying. Like, Jesus, please don't let the snake eat my baby. Because I'm not going out there to save him. So Link trots out there past the snake. He pees. He turns around, trots back past the snake again into the house. Totally oblivious. Doesn't see the snake. Doesn't care. Just, he had to pee. He didn't care. I'm traumatized here. Just freaking out. The beagles didn't go. They went back in the house because I wasn't letting them go anywhere near the snake. But Leek was like, what? Yeah, bearded dragons are reptiles. Yeah, I guess all reptiles do. I don't know about, I guess alligators do too. I don't know. We've never gone down the river in the winter. We always go down during the summer, and we see them everywhere, all over on logs and the bank and all over the place. They're everywhere. Oh my God. You guys just witnessed me go speechless. No ropes. My dad and I, this was years and years ago. I think he was teaching me to drive his truck. It was a stick shift. And there was a snake in the road. And he goes, get up on top of that snake and slam on brakes. And I was like, why? No. And he goes, yeah, kill it. Just slam on brakes on top of it and squish it. Kill it. And I was like, no, you do it. And he goes, no, you do it. I'm like, I'm in the truck. I'm safe. I'm not. So I couldn't do it. I kept missing the snake. I couldn't do it. He goes, stop the truck and get out and I'll do it. I wouldn't get out of the truck. I climbed over. He got out. He walks around. He does it. And then he gets out. We were almost to the house. So I was content just to stay in the passenger seat and let's drive to the house. No, he gets out and he starts walking towards the snake. I said, Daddy, where are you going? He goes, I'm going to go count the rattles. I was like, no, you're not. No, you're not. Get back in this truck now. You are not going near that snake. Get in the truck now. He goes, no, I'm going to count the rattles. I said, no, you're not. You're not. You're not. You're not. You're getting in the truck. And I pitched such a fit that he got back in the truck. I don't know why he thought he was going to go count the rattles for. I mean, I know what that means. It means it's an older snake. The more rattles it has, the older the snake. But what was the point? It could have still been alive. Like, no, absolutely not. You're not going to go count the rattles. I heard, I don't know if it's true, but I heard if a snake bites your tire and you have a cut on your hand and then you change your tire, that venom can get in your cut and you could die from snake venom. I don't know if that's true, but I heard that a long time ago. So, I don't know. You guys, I love our little group. This is so much fun. We always do this after the live stream, you know? We all just sit here and talk. It's so much fun. I don't ever want to leave. This is my well, I can't talk. This is my socialization. You guys are all I have. I mean, I have friends. Well, you are real friends. I started to say I have real friends. You are real friends. But like, I have friends here too, but they're all busy. They have lives. I don't have a life. You guys are my life. I know. I was like, what are you doing? Why? What is the point? Why do you need to know the age of that snake? Are you writing a book? Like, what's the point? I know we're all so much alike. It's so cool. It's just, we've like all gravitated toward one another. And yeah, you guys are so funny. I try to be funny. I'm really not as funny as I think I am. I always laugh at my own jokes and they're usually stupid, but that's okay. I guess I have to go. I have to go adult. I have to go cook. Actually, it's not really adult. I'm just throwing frozen food in the oven. That's not really adult. Oh, I'm exhausted, and this is only day 1 of the trial. We do. Trying to think. Jill's the most central, I think. Let's see. Carla's in Illinois. Judy's in Ohio. Me and Madam are in Florida. Am I missing? Oh, Terry's in Maine. Am I missing anybody? Okay, guys, I'll see you in the morning, and maybe we'll have enough time to finish Mr. Eyebrows. Oop. I crack myself up every time I say that. Oh, goodness. Oh, I could have called if I hadn't been talking to you guys. See, you're a bad influence. I could have called about this bill. Okay, I'll see you guys in the morning. Bye, love you. Mwah, mwah, mwah.